but now this is a question of livelihood. My challenge in the writ petition was commencement of a debarment proceeding. My lord, we mentioned, Lordship said it will come up. We waited for a while. My lord, now we have been debarred. My lord, the difficulty is there are 10 tenders where I have already participated, worth 700 crores. And there are, my lord, by 10th of March, another 1400 crores worth tender, my lord, which I cannot participate because of the order. If Lordship only, my lord, considers whether the order was correct, my lord, the debarment order was correct or not. That's my challenge. Any day, my lord, keeps it, my lord, I will at least, my lord, have the opportunity of, my lord, participating in those processes. Otherwise, I am out of, my lord, total out of, my lord, livelihood. My lord, this is item number 58 of, my lord, today's list. Any day convenient to the bench, my lord, I'll be there, my lord.
58. Let us see today what.
My lord, just in case it is not, my lord, my junior has been trying, my lord, we have waited, my lord, for a while. Lordship was very kind to, my lord, accommodate us in other matters also, where, my lord, similar situations were there. I was only praying, my lord, next week also, if any day, my lord, I can get, my
lord. 9th करो.
I am very grateful.
Urgent motion.
May I have your lordship's leave to mention a matter?
में रख दो. On 9th March, within 10 matters, urgent. Within 10 matters.
Very good. May I have your lordship's leave to mention a matter?
Give all the urgent motion, give the list to my court officer. I will consider, but give the reasons to all.
My lord, just one small submission, my lord. This is an urgent matter, my lord. I'm led by Mr. Siddharth Luthra. Is coming on Monday, my lord. Is coming on Monday. The challenge in the writ petition was an ECIR, my lord, which was without jurisdiction because the predicate offence was closed. When the matter came up before this honorable court, a submission was made on behalf of the enforcement directorate that they are not trying to attach my assets. Basis that the writ court refused interim order to me. Now they have passed a provisional attachment order, my lord, when the predicate offence is closed. And my lord, there is a submission made before this honorable court where the ED enforcement director said that they are not going to attach my assets. I'm led by Mr. Luthra, my lord. He's coming up on the 2nd of March, my lord. If my lord may kindly fix it up as an urgent motion also, my lord.
2nd of March.
We'll try our luck if it is an urgent motion also, my lord.
2nd of March, it is not possible.
My lord, even as urgent motion, we'll try our luck, my lord. It's subject to lordship. My lord, he's coming down from Delhi, my lord, for this matter only.
2nd?
Yes, my lord.
2nd, I don't think.
As an urgent motion, if we'll try our luck, my lord, on that day.
My lord. 2nd motion, this court might be not there.
My lord.
So what?
My lord, then any other day, my lord, subject to the bench, my lord.
Then 6th one?
My lord.
6th.
Very good.
My lord.
Mention, my lord, this similar matter where, my lord, the challenge before the NCLT was stalled, and my lord, they had mentioned in the original side. My lord, remember day before yesterday, Mr. Rajesh had mentioned the matter. My lord, it is on the 31st of March at 3:45. I am on the appellate side, my lord, but the similar circumstances. I was only praying, my lord, if they're also pleadings completed, my pleadings also completed. Both the matters.
Okay, you do one thing.
I've given the number.
Yes. You give.
My lord, lordship, under compelling circumstances, I am praying.
I have
You
just
give.
given notice.
My lord.
Lordship, under compelling circumstances.
Give whatever the mentioning, give the list.
My lord. My lord.
The matter where the jute association has preferred the petition, where there is an order where 20% packaging of sugar must be done. I'm not representing the sugar petition. I'm not a party with the red petition. My application for inclusion as a party is pending. My lord has given direction for exchange of affidavit. That is complete. But any date, maybe even in the next month, Lord, as per Lord convenient.
Okay, you mention the give.
My lord.
Under compelling.
Give the reasoning for mentioning the. I will consider and I will pass it.
Under compelling circumstances, I am praying leave to file and. May I have the lordship's time, please?
ये बोलते
Which number? No, today it is not appearing. Why it has gone out? Okay, give the reason. Give the.
Lordship,
You have mentioned the reason. Give.
under compelling circumstances, I am praying leave to file.
Whatever the urgency, mention in your
My lord, the seat.
My lord, thus leave to file and move this application, lordship, as without any direction and without any cyber crime, the bank authority entirely freeze my bank account. This account is my family business account. Lordship, kindly fix any date as per your lordship convenience.
and you filed it. What is the urgency, sir? There are several thousands of matter of the freezing of the account. What is the urgency?
Please, lordship.
Okay, no
My
problem.
lord.
File it and come.
My lord,
File it and come then.
my lord, the seat of the judgment is not private property of the Calcutta High Court judges, as Honorable Supreme Court judgment set aside by 6 judges of Calcutta High Court.
বলতে দেবে না। 2 বছর ধরে মামলা পেন্ডিং।
Filed an application and he was declared as shell company by one of the SEBI. Now that we have produced all the documents, we have the SEBI has all the documents. Despite that, the SEBI is not declaring out of the list of the shell company. So I'm beseeching your lordship, but anyway, convenient to lordship, it's not appearing in the list.
You mention, give the reason.
I have done that. I have done that.
My lord,
I have also same.
My lord, mine.
I have earlier also mentioned.
Okay, give the, if the reason is there, I will see to that what is to be done.
My lord, my retribution will become infructuous on 20.
Give.
My lord, my retribution will become infructuous on 28th.
Huh?
My retribution will become infructuous on 28th of February. The matter is running under the heading urgent motion since 15th of February. Every day it is going down in the list, my lord. My lord, I have been blacklisted. They have filed fresh tender without hearing me. They have blacklisted me. They have published fresh tender, and if the matter
Have
is
you
not.
given the reason in your mentioning?
Yes,
this?
upon my reason, the lordship has directed the matter to appear in the urgent motion, and thereafter every day it's declining, my lord.
Have you mentioned the urgency?
Yes, urgency have mentioned. My lord, kindly fixes any date, otherwise on 28th, my lord, my writ petition will become infructuous, my lord. It's running in the list since 15th of
What I
February.
am telling, if you, what you submitted, you mention in your mentioning list, then otherwise I have to take all, come on line by line, I will sit till up to 4:30 and I will take all the mentioning matter in the court itself. So your urgent matter will not be taken, I will take only the, whether the matter is to be taken or not, then I will take all the urgent matter in the month of April. What I am telling, your persons are not understanding, give me in writing what is your urgency. If you are not understanding, that court is failed to made you understand. Why you are giving the mentioning list? Urgency is to be mentioned. Then the court will see, if you are mentioning in the urgency, again you are mentioning the total court time is wasting. No circumstance, if for any urgency, you give, otherwise no circumstances.
It allows my mentioning. It was supposed to appear on 24th of February, but it was not featuring in the.
Yes, call the list.
Lordship,
This larger bench matter.
Lordship may be permitted to submit something.
দাঁড়ান না, দাঁড়ান
For money and sexual interest, regular harass হচ্ছি। Hate me by the
আপনি যান না মশাই।
Lordship may be permitted to submit something.
হাইকোর্টে বিচার বন্ধ করেছে, প্রতিদিন হারাস করছে।
May be permitted non-prosecution. লেকচারের জায়গা নয়।
আমার ম্যাটারটা মাইল কাইন্ডলি রেফার
Call the police person. Call the police person. Call the police person.
Don't allow him.
Who is posted here?
But don't allow him to take some steps. This is.
Who is the police person? Take him to the custody.
মাইল আমার ম্যাটারটা আপনি শুনুন।
Yes, yes, do that. Some.
Lordship may be permitted to submit something.
Wants to become. Judges. But, yesterday, my lord, I have submitted the slip. My lord has rejected that. Item 67, my lord has rejected. Yesterday, submitted the slip. My lord has rejected since it appearing as item 70 yesterday, today 67. Not the financial bill next week.
You are not mentioned the reason.
No, it's on that.
Lordship,
पाँच तारीख को रख दो।
একটু উপরের দিকে দিয়ে
Lordship,
so grateful.
Give.
Lordship,
5 তারিখে বলে দিন জজ স্যার।
Yes.
Lordship may be permitted to submit something.
Nothing.
Lordship.
Lordship, there is some urgency, Lordship.
My lord, one small request, my lord. Previously also I had mentioned this matter, like 4 matters, tiger widow matters. Previously, my lord, you have passed it on. Much, I apologize, my lord.
তো সবই আমারও নিয়ে
That's right.
Writ petition is dismissed. You will take from court officer in the unit. Item number 2, this court has held that the NPA is not illegal, but the deduction of the penal charge is not in accordance with the Reserve Bank of India guidelines. No.
Some more time to settle the issue. We need some more time to settle.
I am passing an order, you settle the issue. This is the 4th time. This is the 4th time.
We have talked to the Advocate General. He has spoken to the person concerned. My lord, we need time, give me 2 weeks time. My lord, it has to be the woman has to be accommodated in the hospital. My lord. Somewhere else, because she needs constant.
So your state of West Bengal is not in a position to accommodate one of the patient in any of the hospital in the West Bengal.
No, my lord, we are trying.
And you want to take instruction for the last 2 months to accommodate a patient from the government hospital, private hospital to the government hospital.
Kindly, because I have weak time, my lord.
Why week time? I am immediately call your office, medical superintendent at 2 p.m.
Kindly give us some time. We are trying, my lord.
Why? What steps you have taken? Show me.
The instruction is not with me, my lord. The instruction.
So why you are appearing? You are not having instructions.
I am late by learning.
No problem. Yes, what is the case about?
Well, this lady was admitted to the petitioner hospital, lordship.
All persons is having urgency in the morning hours, and when the matter is called, Advocate General is not there, my senior is not there, my arguing counsel is not there. So why you are mentioning the matter before the court for the half an hour? Appreciate the situation of the court. You have seen.
Madam, I have seen.
Then?
I'm very sorry for what has happened, madam. But I have seen everything. I was present, madam. I have seen everything.
Every day you are coming and I am taking instruction. Your administration is not in a position to take a decision how the patient is to be accommodated in the government hospital. This is the only thing. Can I call your secretary, health secretary?
Kindly don't do that. Lordship, kindly accommodate me, madam.
You are afraid of bringing the secretary before this court, and you are taking the time. Your authority is not in a position to take the decision for give the accommodation to a patient. This is the way the state of West Bengal is working. Every day, yes, the matter is under consideration. It is not so big thing. You have to make a notification at public at large. It is only a patient is to be accommodated in a government hospital. That's all. If your authority is not having this much of the courtesy, so why you are running the state? Total system has been collapsed. Kindly see the order sheet. Since July 2025, you are taking instruction to accommodate a patient from the private hospital to government hospital. Why the husband is required? As per the prayer made by the counsel for the state, for the ends of justice as a matter of last chance, the case is adjourned. Let the matter appear on 10th of March 2026 under the same heading. It is clarified that it made it clear that on the date fixed, a specific instruction has not been brought before this court by the state authorities, appropriate order will be passed.
Grateful, lordship. Deal.
Yes.
Lord, this is that matter. Lord, we found that, Lord, the cognizance has been taken on the very day. Lord, in fact, we got the certified copy, and Lord, I immediately asked Mr. Chakraborty to mention the matter.
Yes, mentioned.
After the matter was over, we got to know that. So, Lord,
Yes.
Lord, what fell from my Lord, we'll kindly, Lord, say that we'll follow that. We'll approach, Lord, the
You file an application before the magistrate and
Yes.
magistrate will decide the matter.
kindly, my Lord, because of the time constraints, your Lordship, my Lord, kindly, my Lord, observes that, my Lord, we file the application, it will be disposed of within a particular time. Because 9th is the date of journey, and my Lord, the passport authority should immediately, once the permission, if the permission is granted, the passport authority should issue the passport.
Yes, Mr. Chakravarti.
That order has to be in consonance with the GSR. Kindly mention that.
That I will.
Because simpliciter permission under criminal procedure code 432.
But in fact, Lord, I educated myself last night after your Lordship indicated that Delhi High Court judgment. But I find that subsequent to the Delhi High Court judgment, there is a Supreme Court judgment.
Supreme Court judgment.
And
Mirror, I am repeatedly submitting, this is not a case at all under 10(3)(b). Impounding so
No,
has not been issued.
but only rider is section 6. My learned friend referred to section 6.
Not 6(2)(f).
6(2)(f). That 6(2)(f) has also been considered. Lord, 6(2)(f) is a prelude to section 10 provision. So, Lord, that has been discussed in elaborately. So, Lord, we need not go into that, Your Lordship.
The only grievance of the petitioner in the present writ application that due to pendency of the criminal case against the petitioner initiated by the wife of the petitioner for the alleged offence under section 85/351 within bracket 2 of the BNS, the passport authorities have not processed the request of the petitioner for grant of passport.
This does not apply post permission.
Full stop. And counsel for the petitioner submitted on after initiation of the case, the police has submitted the charge sheet, and on receipt of the charge sheet, the learned trial court has taken cognizance upon the charge sheet submitted by the police. In view of the above, this court find that as the matter is pending before the trial court, thus the petitioner is given liberty to file an application before the London magistrate for seeking permission for grant of passport, and if I
No.
For going abroad.
Permission to go abroad.
Yes, sir.
No, file an application before the London trial court for allowing the petitioner to go abroad, and if any application is filed by the petitioner seeking permission, the London trial judge shall consider the prayer of the petitioner, if any, in accordance with the notification dated 25th of August 1993.
Lord, subject to correction, this notification does not apply to the magistrate for the purpose of granting permission. Your
No,
Lordships, permit me to look at that. Kindly have a look at it. It says, and in supersession of notification, etc., central government in opinion that it is necessary in public interest to do so hereby exempt citizens of India against whom proceedings in respect of an offence alleged to have been committed by them are pending before the criminal court in India who produce orders from the court. Lord,
From the court.
Yes, therefore, Lord, once the order is produced, Lord, they can't sit over the order.
No, that's why in accordance with this, they will give the permission, then you can apply before the passport authority.
Lord,
What is the procedure? You have to file an application before the magistrate.
Correct.
And magistrate will allow you to go to abroad.
Yes.
For a specific for 1 year, 2 year, 5 years, whatever it is. Once you got the order, then you have to apply to produce before the passport authority, and the passport authority.
only thing I say that, Lord, they should forthwith issue my passport. It is not a question of fresh issue of passport. I have asked for duplicate copy of the passport. My passport is valid till 2032. So, Lord, they should forthwith, Lord, issue the passport. Otherwise, Lord, my
Yeah,
journey
but-
can.
The GSR clearly provides two aspects.
In-
One
is filed by the petitioner, seeking permission to go abroad, comma, the learned trial magistrate shall dispose of the said application by taking into consideration of the notification dated 25th of August 1993 within a period of 1 week.
Lord, 1 week will be too late, Lord. Kindly give us, Lord, a little.
As,
By
ex-
fifth,
as expeditious
we'll file
as
it by
possible,
Friday.
as expeditious as possible as the petition, as expeditious as possible as the petitioner is intending to go to abroad on 5th of June. When you are going?
9th, I'm going
9th
by
of May
5th. By 5th.
2026. Full stop.
By
Full
5th
stop.
of March.
9th of March 2026. If full stop, if the magistrate will pass appropriate order for granting permission, comma, the passport authority shall act in accordance with law for issuance of the passport to the petitioner as early as possible. Writ petition is disposed.
Now, what is the 9th date of journey?
My cool within 10 seconds.
We have seen what. We have seen so many courts, particularly the restricted event crowd. Chief Judge Losby allows all the learned advocates
That is
to file this leave mentioning the urgency. And then this crowd can be discussed.
no, I am again. Why today has happened? For the last 2 weeks, I am telling you the mentioning list. In spite of that, they are mentioning.
Even
That is
the
the
called out mentioned.
mention.
I just want to apologize, my lord, on behalf of this gentleman. I tell your lordship why. If your lordship looks at the record, your lordships will find it started with Justice Sanjeev Banerjee. He was very, very sympathetic towards him. He was passing order, but certain things happened where, my lord, he was compelled to release the matter. And after that, the several judges have released the matter. So, my lord, your health, your lordship's health comes first. Kindly take care of your lordship's health. Your lordship, don't get distracted by these things. This happens. And this is
That's because and that's why I find that okay, give them. I am spending my 45 minutes or 1 hour in my chamber for taking all these things, mentioning this.
Lord, the manner in which this gentleman has expressed his wrath is questionable because your lordship is not guilty of discharging or releasing any matter.
I know it personally because I had occasion to appear on behalf of the High Court administration. I was opposing those matters. And Lord, I know that this is not solitary occasion. This has happened, Lord, repeatedly.
Repeatedly.
So just look after your lordship's health. Kindly, Lord.
Thank you.
Facebook, he posts that he goes and abuses the judges. He
No, everywhere. In everywhere, this type of the persons are available.
Forum is to write a letter to the Chief Justice for assignment.
Yes, next. Thank you. Thank you for advice.
Time for the petition.
Next.
Time for the petition.
Yes.
I was instructed to serve on them and file as affidavit of service, which
Have
I
you
done.
served?
Yes, madam.
What is the matter?
Well, the matter is that hereby I am challenging the other respondent authority for non-payment of GST. Well, as per law, there are two components. On the gross value, they have to deduct TDS and pay the GST over and above. Now,
who is appearing for the GST authority?
Well,
the petition has filed the present application being Can 1 of 2025, praying for recalling of the order dated 19th September 2025, wherein this court has dismissed the writ petition number 21343 of 2024 for default for non-appearance of the petition when the matter is called. Full stop. Counsel for the opinion submitted. The matter was dismissed on 19th of September 2025 and immediately on 11 November 2025, the petitioner filed the present application for recalling of the order. He submitted that on the date fixed, the petitioner could not appear before this court as the learned advocate on record inadvertently oversight the matter listed in the monthly list. Consider the submission made by the counsel for the petitioner, peruse the materials on record. This court finds that the petitioner has shown sufficient cause for non-appearance of the petitioner. Accordingly, order dated 19th September 2025 is recalled. WPA numbers 21343 of 2024 is restored in its original file. Can number 1 of 2025 disposed of. List of the affidavit of in spite of in spite of service of notice, none appears on behalf of the respondents. Affidavit service be kept with the record. List the WPA number so and so under the heading urgent motion on 19th March. Next,
My lord, can it kept on the third week, my lord? I will be in the circuit bench for that entire week.
8th April kori then. In the combined monthly list of
My
April.
lord, 8th April, my lord.
8th April. Next. Call list.
Lord, I beg to appear on behalf of the petitioner, my lord. But tomorrow, my lord, my interim order is going to, my lord, expire, my lord.
What is the interim order?
My lord, interim order, my lord, was initially granted on 17th of October 2023. Lastly, my lord, it was extended on 19/12/2025.
19/12/2025.
19. That
Yes.
was last
Matter is ready.
matter is, my lord, ready for hearing, my lord.
What is the matter about?
But this matter, my lord, relates to, my lord, trial by media. My lord, the petitioner is, my lord, belongs to a political family, my lord. Petitioner's name and her family members' name, my lord, have been, my lord, published by the media in such a way in respect of the criminal pending cases as if, my lord, they are the, my lord, real accused of the real culprit, even before the charge sheet has been filed.
Yes.
I am appearing for Enforcement Directorate. I have been dragged in unnecessarily.
It is good for you. Yes. Who is for the main respondent?
The media house.
Entire media house.
All media. All media. So what you have prayed for? What is your prayer?
But kindly comes to.
What is your prayer?
My lord, there are a lot of pleadings, but my lord will give 15 minutes to this matter. My lord has experience of these sort of matters. My lord will dispose it of. This is what I understand, my lord. Because they have asked for a gag order on the media from publishing anything with regard to a litigate or with regard to the investigations of different cases.
Now, absolutely, my lord, not, my lord, subject to honor correction by my lord. Absolutely, my lord, not. My lord, selectively, my lord, my name and my family members' name have been, my lord, picked up in respect of, my lord.
Why you persons are not going to the civil court and get appropriate orders? How the decree can be passed in this writ application under 226?
My lord, goes to the, my lord, interim order. That was a
Maybe I am not disputing that, but what would be the final result? I mean, under the 226, can the court can examine all these things? Under the question of defamation, you have to prove. Then only the court can go into that. Only by seeing the paper, it cannot be.
My lord, subject to correction by my lord, manner in which, my lord, media reporting has been done.
Okay, no problem. So I am.
No, but the media cannot be gagged by the Constitutional Court. Constitutional Court cannot take away somebody's constitutional right. What is the prayer?
That's what I'm telling.
This prayer should be outright rejected with deepest of respect.
But what can be done? They are enjoying the interim order now. This court has.
While kindly takes it up, Miller, for hearing, I think this is a very serious implication.
I am fixing a specific date for hearing, extending the interim order, so the matter can be disposed. The matter is listed as to be matter is listed for on the prayer of the petitioner for extension of the interim order. It is submitted by the learned counsel for the parties. The pleadings have been completed and the matter is ready for hearing. Learned counsel for the petitioner submitted the interim order is till the end of February 2026. Accordingly, prays for extension of interim order. At the learned counsel for the respective parties, this court find that the matter is ready for final hearing and the petitioner already enjoying the interim order since beginning. Thus, for the interest of justice, the interim order is extended till give the date for final hearing. April में कौन सा date है? दो 12 बजे मत रखो, 2 बजे अप्रैल में
शायद कौन रखते हैं
23-24 अप्रैल देखो, 23-24 अप्रैल खाली है, 27 अप्रैल 28 अप्रैल 24 खाली है 2 बजे till 24th of April 2026 or until further order whichever is earlier. Let the matter appear on 24th बोला ना 24th April at 2 p.m. as specifically explained.
24th April. My lord, enforcement directorate, my lord, moved Supreme Court as well against that interim order that was not dismissed.
No, that's why I'm telling.
I will
Already
give befitting reply, my lord.
next.
I'm grateful.
Call. Yes.
Right.
Yes.
And your lordship,
Kindly look at it.
and your lordship, may please to come at page 36 of their writ petition, your lordship.
36.
36. Lordship, in the affidavit portion, your lordship, in para 3, your lordship, they affirm the same, your lordship. Was written here, your lordship, that I hereby declare and affirm that there is no outstanding amount payable by the minister, the state government or central government, their undertakers, or any statutory autonomous body under any ministry, and they affirm the same, your lordship.
Yes.
I still say that.
Your lordship, and the same was written in the clause D, your lordship.
Correct. Correct. I am not on that. See, this is auction for what? For what? Auction for which what work?
The toll, your lordship.
Huh?
The toll.
Toll. Toll is not much contract. Correct. Toll plaza is not a much contract. In the state, maximum 4 or 5 what might be. Correct. If this condition will continue to the other works as like construction, what will happen? You see the negative part. If I am having enmity with you, and I know the next year the tender will come, I initiated false money suit against you. And in the tender, I will give, yes, see, this is the money. Might be it is a false case.
Yes, I'm grateful.
One thing. Second thing, in this present case, the authority PWD has given you intimation that the money claim is there. He has challenged the demand made by the PWD. That is to be adjudicated. If suppose tomorrow that adjudication comes in favor of the petitioner, no, the demand is wrong, And due to that communication, the petition is not getting the this tender. Who will suffer the damage? Who will suffer the damage? See, the condition, it is correct, it is a settled position of law by the Supreme Court. Condition in the authority is the expert to put the condition in the tender document. The court sitting in the writ jurisdiction cannot override the conditions. But the simultaneously court has to see the condition in accordance with law and not in arbitrary manner.
Not tailor-made.
Not tailor-made.
That is the expression.
Correct. So that's why, so if suppose here he is telling that the affidavit which you rely upon, he has submitted, and you have obtained the document from the PWD, but that is the dispute that is pending before the court. So what would be the effect? If suppose A is having the criminal case, and due to the criminal case, he has not been granted some benefit. Subsequently, he has been acquitted from the criminal case. So that I want the justification from you. Who is your senior? Mr. Bose?
Solvency is also not disputed, my lord, because if a lordship sees.
And solvency is there.
That
Yes,
issue
senior.
the solvency certificate. And if a lordship may kindly recall, I've shown my lord page 39, that is the chart. But they were so much eager to know about the dues that I believe they have also found out about the successful bidder for whom this condition was made. But the chart at page 39. At page 39. He was working in Madhya Pradesh. So they would have got information within 1 day from Madhya Pradesh that he doesn't have any due. So this was tailor-made. This is judgment with regard to that, with regard to tailor-made also, like a side that judgment.
When your senior will, yes, come.
No, he's for the state.
I'm for this.
Who is your senior? I don't want that you should be in burden.
Your Lordship, his wife made an accident last day, Your Lordship. That's why he's not able to come. If Your Lordship may take this matter any day next week, Your Lordship, then he will able to come.
I want the justification.
I'm good.
I want this justification, not for this purpose, for the whole, because the condition which has to be given, that has to be considered as a whole, not a particular. Correct. So when?
Next week.
Next week. 6th.
6th.
The Learned Council appearing for the state, for the Jilla Parishad has filed a report dated 23rd of February 2026 after serving the copy to the Learned Council for the petitioner. Let the same be kept with the record. Learned Council appearing for the Jilla Parishad submit that the arguing council is having some personal difficulties and as such is not in position to appear before this court. Taking into consideration the considering the above, the case is adjourned. Let the matter appear on 6th March under the same heading, under the same heading. Okay? In same position. Next.
My Lord, Election Commission, we are filing our affidavit. Your Lordship, the LIC दी
No, I'm Election Commission.
I'm appearing for LIC. This is my affidavit. When my junior had gone to supply a copy to the Election Commission, they asked for 2, which is not supposed to be given by us. We are ready to give 1 copy, which is ready.
My Lord, this is my reply to the LIC, my Lord, and Election Commission, my Lord. They have just received it.
But it seems to be without.
No, I'm not going to find it.
Yes.
But it seems to be clash of interest between the Election Commission's sovereign duty and LIC's official duty. But we cannot be sandwiched between them.
Now, Mr. Bhattacharya, you can take the benefit of the present judgment of the order of the Supreme Court.
No, they have been.
That's true. I say that. I am that I am bound to carry out the sovereign duty. And if I carry out the sovereign duty, my employer says you will face the penalty. That I have to be saved from penalty. I don't want to avoid the sovereign duty.
Cannot, penalty cannot be.
The hearing cannot be possible because today the affidavit of opposition was given by commission and the reply was given by the petition.
Why you are not coming with a positive reason? Because see,
have given a affidavit. They have been deployed as micro observers who are also assisting the honorable judges in this SIR
Correct. That
process.
is not the problem. You utilize the service. I am not going to stop that. You utilize that, but only to give the assurance in writing in affidavit. Yes, whatever but the insurance company will not take any adverse.
That's all.
The
That is
petitioner
to be
in the
given by LIC.
no. If you because they are working there. So because now the work of the LIC has been done, so you can direct either you can direct the LIC not to take any adverse against the petitioner. So that will be recorded. That means
Yeah, that's all. That's all.
you direct the LIC.
Let that be a court's order, Your Lordship.
Then I had to hold on merit.
The Election Commission, being a constitutional authority, has the authority to direct.
You are also the constitutional authority. Correct.
And I'm serving my.
Now you are also having the present day-
Judiciary, the judiciary is also we will accuse
That's the
requisition for the purpose.
That also you are having. So, the respondent number 1 and respondent number 5 and 6 have filed their affidavit in opposition. Full stop. Petitioner has filed the reply to the affidavit in opposition of the respondent number 5 and 6. Let the same be kept with the record. You will file the affidavit to the reply to the 1. The counsel for the petitioner prays for
Filed by reply to the LIC.
5 and 6.
Yeah.
One.
One we had served them by email.
You will file the reply to this. The counsel for the petition prays for time to file reply to the affidavit in opposition of the respondent number 1.
Kindly
That-
record that copy was already served.
That the affidavit in opposition be filed within 2 weeks. Within 2 weeks. List the matter. List the matter on 24th March. Under the same heading.
Deeply obliged.
Next.
My lord, 10 and 11, my lord, I am for the petitioner led by Mr. My lord, pursuant to your lordship's last direction, this is my supplementary.
Party application.
Who are you?
We are the selected candidates. We got
Item 10 coaches or 11 coaches?
11.
Item 10.
8 or 10.
10 and 11 both have been taken.
Okay. So you file the affidavit supplementary.
Yes, my lord.
My lord, my learned friend has filed a supplementary affidavit. My lord, I have, with respect, my submission would be that by a supplementary affidavit, he cannot challenge something which has seen the light of the day after filing the writ petition.
My lord, I have
It's
my
for him to,
prayers.
if he sticks to his earlier prayers, it's all right. But that will not help him in getting the new one, which we have formulated now, which is dated
27 January.
Yes, 27 January. Anyway, it's up to him.
Yes, this is if you are agreed with that, how the supplementary you
My
can.
lord,
Yes, Mr. Bhattacharya.
No, but since the matter is being considered by the court in respect of the main prayer, this will in aid of that. Learned Advocate General will clearly consider, as I repeatedly say, but this is not a really adversarial one. Question of granting the benefit of reservation in terms of the statute.
Correct.
What they have done, we wanted to point out, this is not really fulfilling the purpose. To just point out to your lordship. Not that I am challenging the validity of that. I am pointing out that the remedial measures which sought to be taken is not the appropriate measure for that purpose. I think it should be considered in that light.
In that case, may I come back by filing affidavits? Because in the main rito to.
yes, my lord, there was a direction, my lord.
When is out?
And I am sure that if the advocate general applies his own independent mind, he will come out with a solution. There's nothing, no difficulty in it.
Advocate General is always independent.
No, that he may not always be under pressure.
That always there. The petitioner has filed the supplementary affidavit in terms of the order dated 4th of February 2026 after serving the copy to the learned counsel appearing for the state. The learned advocate general prays for time to file affidavit in reply to the affidavit in opposition to the supplementary affidavit. Let the affidavit in opposition be filed within 1 week.
Milord, I have to file my affidavit to the main writ in that case also. I have missed my chance. I must be candid. Give me 2 weeks time so that
Within
I
2
can
weeks.
file to the both.
2 weeks after supplying the copy to the London Council for the petitioner. Petitioner is also liberty to take file reply to the same within a period of 1 week. Within a period of 1 week, list the matter. 30th March. At the same meeting.
Affidavit of service.
You're not touching this. Not challenging us. So what is the prayer in your original writ application?
Secondly, after West Bengal Board of Primary Education passes the notification for issue. In the recruitment process, they have selected the vacancy in terms of this notification. My challenge was that since I have challenged this, the recruitment vacancy should be also not modified. That was the prayer to be. And no matter the stage of selection is there, or is the it's a new process just started, not yet been totally no panel has been prepared, no selection has been. That is the
So you are not pressing at present B.
No, I am appearing for the board, but I am bewildered. I am bewildered. Now the main notification.
You are appearing for?
Primary board.
Board.
Now the question is, if the main notification, the new afresh which has been issued by the state government as placed by the learned advocate general, if that is still in question before the court, then how the process will go?
That is the process. So what I propose, already I fix on matter on 30th.
Take both the taken together.
Let this matter also come on 30th. Come on 30th, so both the matter can be. So this court will whether that notification or 27 January notification.
We will make our stand clear, my lord. If anything required, I will give him a copy by of affidavit.
Because earlier notification will continue only with regard to the roster portion, the 27 January.
My lord, I think, my lord, is off the record. In primary education selection process, there is no post-wise vacancy, reservation. Suppose I tell your lordships, in the higher secondary selection, school-wise post is reserved for reserved category. Now in primary election, suppose your lordships 10,000 vacancies declared. The learned friend is, my lord, being a physically handicapped candidate, or now what is the especially disabled candidate, 4% is reserved. So the 4% out of 10,000 always kept aside. So there is no post-wise vacancy. My learned friend need not be worried about that. If ultimately your lordship finds 2026 notification is good, what will follow that? But that's off the record.
That's my prayer today.
That's off the record.
File an application for addition of party because we're at any order passed by this court without.
In which matter you filed the application? 11. So let it be kept with the record.
Let it be kept with the record. And one more submission, there are 132 writ petitioners. Whether the court fees have been paid,
my learned friend is not a state officer, so he has nothing to say on that.
It is your duty to pay the court fee.
Okay, okay, I will see to that on the next. As the analogous matter is fixed on 30th March 2026, let this matter be appeared on 30th March and along with the other matter being WPA number 21556 of 2020.
In the meantime,
in the meantime, if the respondents intend to file any affidavit, they can file the affidavit within 2 weeks after serving the copy to London Council for the petition liberty to file a reply within a week.
Well, regarding my application,
The intervener has filed an application being CAN number 1 of 2025. Let the same be kept with the record. The same be considered at the time of hearing of the report.
great.
30. Well.
Recall this is relating to, my lord, the keeper post under West Bengal State Archaeology, my lord, the service. Lordship was kind enough to direct the PSC authority to produce, my lord, the original record in a sealed cover.
Yes,
Last
yes.
order.
I'm appearing on behalf of public.
But I appeared for respondent number 7.
All 3 things are there.
All the
Interior board, copy of the recruitment rule of the post of keeper and
Yes.
State Archaeological Museum, if any, and constitution of the committee. And for constitution of the committee conducting interview within 2 years.
এই খামটা দিন গো। খামটা ও কাটছে।
How many posts was there?
one post.
1 post.
Yes.
The constituted.
Yes, that is constituted, but my lord, kindly see the rules, my lord, which I have given to your lordship, my lord.
Direct recruitment department having requisite qualification. That is not the question here. Qualification of direct recruitment, desirable training. Yes.
Rules, though the rule specifically does not say about the constitution of the
Correct.
interview board, my lord. The PSC has the power to constitute a board.
Correct. Where is the board constitution? See, I have.
Yes, I'm giving in terms of the order sheet of the internal order sheet of Public Service Commission, they constitute a board.
Correct. How the marking was done?
Well, this is the list of advisors And this is the note sheet to constitute a board by the chair.
Board. Apurva. Where is Apurva name?
Yes, Lordship.
Where is Apurva Bhaumik?
Kindly. It is in the note sheet. It is in the note sheet.
Yeah. You are not doing the homework in the chamber. You are not calling all the records in the chamber.
They came with the file today.
That is the difficulty of the administration.
Yes, Lordship. I tender my apology, Lordship.
And one thing, second thing, see, if how many members board? Three members board?
Members. Two
Correct.
advisors,
Three members
one
board, three advisors. Three members board, we are having the three mark
Yes, Lordship.
sheets.
Yes, Lordship.
Three seats, and they
Yes.
have to give their own independent mark.
Yes.
Correct.
Yes.
Where is that?
My lord, I have handed over the interview sheet in the sealed cover. My lord, there are three members.
Three members, they have all given 70-70. How it is possible? That's why I did not want to disclose. 70.
Yes.
So if each person is having how much mark?
Okay.
And how the all 70 will go into the 210, and your total mark is 100.
Then in this regard, I have to take instruction from the officers because they are not the officers.
I know this would have been happen.
And I have to take instruction from the
What instruction?
What is the procedure? What is the
If
procedure?
If your procedure, nothing. This is a procedure. If the three board members have been constituted, the three board members will be there. They are having their own calculation sheet, and they will be given. Okay, not 100, but it's not all will give 70. Either you will give 40, he will give 2, he will give 10.
Yes.
Here, if you see, all have given 70.
Yes.
All persons same. One person 42, all the two has been given 42. One person has given 60, all have been given 60. So it will be 210. If the mark of the petition is to be considered, that will be a 210. And the total mark is 100. How it can be possible?
In this regard, I have to take instruction later.
And second thing, I am telling one thing. Give that order sheets.
Order sheet.
Again, I am telling you. There is another lacuna.
अच्छा ओ अच्छा मतलब এখানে যেটা লেখা আছে না অ্যাডভাইজার
এই অনারেবল মেম্বার এখানে লিখে দিয়েছে অনারেবল মেম্বার এবি এবি মানে অপূর্ব ওই নামটা
Where is that? Another sheet was there, no?
another sheet it is in the file.
What is AB? HMAB?
AB means Apurva Bhaumik, the honorable member.
Advisors marked as 1, 2, 3, and 4. 1, 2, 3, and 4. Where is that? This advisor marked as 1, 2, 3, and 4. What?
Well, 1, 2, 3, or 4, we have approached before the advisor. Those advisor who confirmed, they will only take the interview. Two advisors confirmed. There is written 2 advisors confirmed and honorable member. Chairman has written that honorable member be the board presided by honorable member. AB means Apurva Bhaumik.
Okay. So you take the how this mark?
Yes, my lord, we have our own rules and procedure, my lord. As per our rules and procedure, we take all the marks of the three members, and thereafter we make it an average marks. My lord, it is written as average, the average mark, final average.
That's why each person how much marks has been awarded. Where is that? Because you have given all 3 numbers. All 3 has given 70, 70, 70.
My lord, it is the average marks.
No.
Yes, my lord. All the 3 numbers, 3 marks.
Where is the separate marks?
Separate marks, my lord. Then I have to take instruction from the authority, my lord. Where is the separate marks and what is the rules and procedure? It is the rules and procedure of Public Service Commission itself.
When the interview was held?
Average marks will be given.
1st July, 2nd July, 3rd July. Why 3 dates?
Interview date. Candidates are not same. Though there is lots of candidates, so all the candidates are divided into 3, and 3 dates are taken. The separate candidates are taken on 3 dates.
So record an order.
May I make a small submission? My lord, so far academic qualification are concerned, whether they have given any weightage or not, my lord, it is settled proposition of law. In the event of selection is made on the basis of Bhaibabusi, then they are to take into consideration the academic qualification, then the question of Bhaibabusi. I don't know, my lord, what is there.
That's nothing.
There is nothing. At the same time, my lord, this is required to be taken into consideration, my lord, because of I have, my lord, much more better qualification. Even he is not a PhD holder.
That cannot let me
Deeply
check.
applied.
The-
That was not a part of the advertisement also, that a better.
In terms of the order passed by this court dated 10th of February 2026, comma, the learned advocate appearing for the
Public Service Commission, West Bengal.
that's one number
3, 4, 5.
3, 4, and
Three.
5.
3, 4, 5, and 6.
3 to 6. 3 to 6 have filed a sealed cover. Filed. नहीं क्या बोला? Has produced the interview sheets wherein the marks to the candidates who have appeared in the interview has been noted. The respondents also produced the original file wherein the board has been constituted for conducting interview. After going through the mark sheet, this court find that there are altogether 3 members in the interview board, and the interview was conducted on 3 dates, that is on 1st July, 2nd July, and 3rd July. And all the 3 members, but the authorities have not produced the marks provided by each of the members during the interview. And as such, the respondent number 3 to 6 are directed to produce the marks provided by each of the members to the candidates appeared in the interview on the next date fixed in a sealed cover. How much time you will take? 2 weeks. Let the matter appear within 2 weeks. Let the matter appear on 13th of March 2026. Under
Only one indulgence, my lord. In the event of any appointment is made, that is subject to the result of the set application.
Automatically it will go.
Line, my lord, can satisfy, my lord, 12% those who are
Initially
here.
you have not taken that plea. How is that?
No, my lord, taken. My lord, because of
this
at
may
that
be-
point of time, documents are not
Let
with us.
this document be resealed and be kept with the record.
Diploma.
इसको reseal करिए, document रखिए.
The 13, I am for the petitioner led by Mr.
Lord, before taking up the matter, my lord, I have one submission subject to your lordships.
वो फाइल उनको दे दो, ऑफिस फाइल है ना? Yes.
No, my lord, before taking up this matter, my lord, I was in the midst of argument. My lord, it will take little time. So if your lordship takes it up any day at 2 p.m. so that I can do it in one day. My lord, my suggestion, if your lordship takes it up on 6th
6th
of March, because before that,
I don't find it because 6 matters.
so I will take little time and the motions will be, my lord, just before
till April, that's why I'm fixed.
6th March, your lordship.
Well, you can complete.
কমপ্লিট করতে গেলে অন্যদের মোশন চলে যাবে আমি বারবার বলছি না সময় লাগবে একটু তাড়াহুড়ো করে আমার ব্রেক হয়ে যাচ্ছে
তুই কি একদিনেই করতে পারবি 2 PM থেকে সুবি
You bring that.
এটা কি একটা সেশনে শেষ করতে পারবি তো
হ্যাঁ হ্যাঁ সেটাই আমি চাইছি সেটাই চাইছি টান আদারওয়াইজ
How much time you will take?
মানে 1.5 hour I will take.
Not one session.
No, one session you will do that, your loss. If it takes up to 2, I will by 3:30 I will complete.
Wait, date খালি আছে কি?
কারণ আমার তো অসুবিধা হচ্ছে আমি নিজেই তোকে কতদূর বললাম আবার ভুলিয়ে
It
যাচ্ছি
will go in April.
Any day convenient to
But the petitioners are suffering long back. Their merit list also, my lord, given. They're above the last selected candidate.
এইটাতেই তো লাগবে আরে সেটা দেখা আমাকে মুখে বললে কি করে কোর্টকে দেখাতে হবে
খালি আছে 23rd and 24th at 12 noon.
Oh, deep Lovelace.
23rd
The
and
matter can
24th
be
March.
23rd and 24th March at 12 noon. As per the prayer made by the council for the state, council for the WBPPE, the case adjourned. Let the matter appear on 23rd and 24th March 2026 at 12 noon for as a specific matter.
My lord, may I have your lordship's kind indulgence? My lord, with regard to the item number 12, there was a direction to submit the original interview sheet in a sealed cover. My lord, original interview sheet is there. My lord, can I replace it with the Xerox?
Let it, that's why resealed here. Let it be kept here. I have resealed.
Okay, my lord. Great.
My lord, item 14, 15 also, my lord, same.
14, 15 same.
My lord, the issue is the same.
13 to 15 same kori. Yes, next.
16, my lord, I am for the petition. It was that matter, my lord, where I disturbed your lordship regarding mention. My lord, here, my lord, before your lordships open the way, if I am telling your lordship, my lord, I am a private.
Which for the state?
My lord, I have served, my lord. Yesterday also, I have mailed that the matter was mentioned, my lord. This is my affidavit of service. My lord, Mr. Shantanu Kumar Mitra is appearing. My lord, the case is, my lord, I am a private nursing home. From in 2023, my lord, I was granted certificate of clinical establishment certificate by the health department to operate. And my lord, it was written that initially you have to obtain the fire safety norms and other. I obtained everything, my lord. There was a checklist from the fire department that I have everything. But there was certain recommendations was required to be given by the fire department. My lord, from 2023, I have annexed all the representations. I have asked the fire department to kindly come to our hospital and conduct the survey so that you can provide us the recommendations. My lord, they did not. Ultimately, in November 2025, my lord, the health department cancelled my certificate. I wrote to the health
Cancel
department.
certificate license.
License. Cancel my November 2025. Suspended rather, not cancelled. My lord, I wrote to them that see, there is no fault on my part. I have all these certificates. The fire department is now coming. Considering that, my lord, immediately after 10 days, they renewed the license with a condition that by February 25th of February, that is yesterday, 2026, I have to give the fire recommendations. Thereafter, again, I wrote to the fire department, kindly come. Ultimately, my lord, on 30th of January 2026, they issued a 50 recommendations. What are those recommendations? Mainly, my lord, I suppose, my lord, I have 3 staircases. They said you have to make additional 2. My lord, the width of the road is 30 feet. They say if it is possible, make it 40. These are the recommendations, my lord. Now, my lord, I wrote to the health department. I immediately issued a work order to the persons, my lord, who will conduct those things. I say, my lord, if these works are cannot be completed within 25 days, kindly allow me another 5 months time, 4-5 months time, so that I can do it. So, my lord, I straight away take your lordship that I have the fire safeties, my lord. Your lordship, kindly come to page 98 first.
So it is suspended up until how much?
My lord, it is now, yes, they said that up to February 25, you have to produce it.
25, 26.
25, that
25th
is
February.
yesterday, my lord. My lord, kindly come to page 98 first. See, my lord, this is from the Department of Fire. Kindly see all thing I have, yes. Lift, everything, every protection I have. So it's not the case that I do not have the fire. Recommendations page. 30 January.
Yes.
My lord, thereafter come to page 70.
There is a signature of the authority.
Yes, my lord, at the last page.
101.
At the last page 101.
There's no signature.
My lord, my lord, this is the officer in chief. This is the stamp, my lord. This is what I have been.
Signature. Where is the signature?
My lord, it is in the bottom, my lord. It is very faint, my lord. It is the stamp and the signature.
Okay, but here there is nothing. Okay.
Lord,
then,
my lord, thereafter page 76, my lord. My lord, kindly see the date when it was issued to me.
Yes.
30th of January 2026.
What is this?
This is the recommendations of the fire department, which the health department is wanting. I am ready to comply, but this has only come to me on 30th of January. This kindly see all the recommendations. These are 50 recommendations. I immediately wrote to the health department. I have received this. I have issued the work order.
When you establish your
My lord, in 2023, and from 2023, I have the annexures. My lord, kindly see the.
So when you established, so all these formalities were not completed.
No, my lord, this has to be done, my lord, after the license and everything is awarded. Page 61, if your lordship first kindly comes. My lord, this is the first application. Kindly see the date. On 23rd June 2023, I applied before the, thereafter all the recommend. How many times I have applied before the Department of Fire, my lord? Kindly see all the dates.
No, when you have been when the license was provided to you?
In 2023, that is at page, my lord.
3 years, my lord.
My lord, page 50.
Plus, is the inception of the establishment of this establishment. My lord, he failed to produce, my lord, the mandatory statutory requirement, my lord, mandatory statutory requirement, my lord, fire NOC. Kindly see his own document. While unadmitted stating the actual state of affairs, my lord.
Let it complete. I will come. Yes.
My lord, kindly come to page 50 first. This is the certificate. My lord, now the clinical establishment.
This is not the certificate. This is any trade license. This is trade license, mere, not certificate.
52.
Yes.
And on page 52, this is issued by the CMOH.
Correct.
My lord, after this certificate, they said you have to obtain the fire. I immediately applied before the fire every time. You kindly come unless the fire, my lord, issued the recommendation. My lord, I cannot. They allowed me to continue. They said for you do it. Ultimately, my lord, on 30th of January, and my lord, they also granted renewal, my lord. It's not that I cannot operate. Ultimately,
No, this license was issued. What is the date? 25. 13 January 2025.
No. In the year 2023, we have
page 52.
Page 52, my lord. It is second paragraph, my lord, from 2/2/2024 to 1/2/2027.
Correct.
Because they gave a condition that you produce the recommendations after completing the recommendation. My lord, now kindly see my representations which I made at page 60 onwards, my lord. Whether there is any malafide.
Now, whether this license contain any conditions that
Yes,
subject to conditions.
mandatory conditions, my lord.
Where is the conditions in the license?
My lord, kindly read page 67.
If your lordship goes to page 67, the sequence of events are there.
Well, I will show from my bunch of documents, my lord, the sequence of events. Because it is his assertion.
My lord, page 67.
My lord, he has sworn affidavit before the my lord statutory authority that he would provide without fire license, which is mandatorily my lord required within 4 months. That is in the year 2023. And thereafter, my lord, on his asking, a date has been fixed, my lord, after two renewals and after, my lord, numerous show causes, numerous hearings, numerous meetings, my lord, on his, my lord, request, a date has been fixed, my lord, cut-off date is fixed, my lord, on 25th February 2026. Up to that, my lord, license would be, my lord, they would show the establishment. Thereafter, if within that period of time, by, my lord, 25th February 2020, if they are not able to, my lord, produce the mandatory fire no objection, then automatically from that date, my lord, the license would be terminated. This is, my lord, kindly read that page 67. May I place? Whereas CE license in respect of your clinical establishment, such and such, was initially issued on 2nd February 2023, valid up to 1st February 2024. Upon your submission, an affidavit assuring submission of a valid fire no objection certificate within 6 months, but below affidavit says within 4 months. In terms of section 8.1 and 8.2, read with section 9.1 of the clinical establishment of 2010. Whereas you, it should be 2017. Whereas you have failed to submit the said NOC within the stipulated period, despite repeated email communications from this office. Whereas after expiring of the said license on 1st February 2024, you also did not apply for renewal, though clinical establishment portal in due time, through clinical establishment portal in due time in violation of Rule 11 of the rules. Whereas a show cause notice was issued to you with a memo number such and such dated 5th February 2024 for non-submission of the renewal application. Whereas after issuance of above show cause notice and repeated discussions, you applied for renewal only on 6th April 2024 for 1 year. However, due to non-compliance with queries, you compelled to modify the application seeking renewal for 3 years without producing the statutory fire NOC, causing further claiming further time, which is consistent with Rule 7.1 or 7 Rule 2. Whereas the renewal license was issued on 13th January 2025 for the period from 2nd February 2024 to 1st February 2027, with observation of irregular functioning during 2nd February 2024 to 10 November 2024. Whereas several official emails thrice were sent thereafter to submit the fire NOC, but you neither complied nor responded. Whereas a personal hearing was conducted on 3rd October 2024 for operating without fire NOC since inception. You again sought further time, citing inconsistent inconvenience. Whereas despite the above, a second personal hearing was granted on 27 May 2025, wherein you again sought further extension, reflecting lack of sincerity and willingness. Whereas after expiring of the extended period of fire NOC submission, another show cause notice, this is the fourth show cause notice, was served on 15th October 2025, asking why the license should not be cancelled under section 1301A B of the Establishment Act. It should be 2017, date with Rule 13 of the Rules 2017. Whereas instead of compliance, you repeatedly requested further extension. Whereas the facts establish that CE has been operating without a valid fire NOC from 2nd February 2020 till date, in breach of section 8, subsection 1, subsection 2, section 9.1, section 13.1 of the Establishment Act 2017, read with rules such and such rules, constituting thus gross statutory violation and posing significant risk to patients' safety. This is foremost. Now, therefore, in exercise of powers under section 13(1)(a)(b) of the Act, read with rules, the clinical establishment license of such and such hospital is hereby suspended with effect from 25th November 2025 until further orders. You are further directed that during the suspension period, no new patient shall be admitted. All existing admitted patients shall be safely discharged within this period, so that no patient faces inconvenience. This direction is issued under such and such section.
Come to page 70.
Compliance shall be strictly monitored. Thereafter, your lordship kindly takes page 70.
Yes.
This is the Milord. No, প্রথম থেকে পড়ি। Milord kindly takes Milord ultimate paragraph, last paragraph. Milord, now therefore this sentence starts. Has your lordship got it, Milord?
Yes.
Penultimate paragraph. Now therefore, in excess of powers conferred under section 13(3) of the Act, read with rules, and section 23 of the Act, read with rules, the earlier suspension order in respect of the clinical establishment license and the PNDT registration certificate of your clinical establishment are hereby temporarily withdrawn with immediate effect, subject to the following strict conditions. You shall submit a valid fire NOC issued by the competent fire authority by 25th February 2026. No further extension of time shall be granted under any circumstances. Failure to comply within the stipulated period shall result in automatic cancellation of your license under section 13(1) of the CE Act 2017 and your PNDT registration certificate under such and such section without any further reference. During this conditional period, you shall strictly comply with all provisions of the said Act and rules, including maintenance of records, safety standards, and transparency obligations. Milord, are you 3 months of validity expired, my lord, if your lordship kindly takes the bunch of documents, my lord, on they are documents. They have not annexed this document. My lord, kindly sees sequence of events.
No problem, I will hear.
My lord, kindly see the last annexure. This is the sworn affidavit they have filed.
Takes it up in a descending order from.
Yes,
back to
descending order. Has your lordship got it, my lord? Last page, page 2,
Part of the affidavit.
part of the affidavit. I have solemnly affirm and declare that I will submit the fire energy immediately within 4 months to the licensing authority on receiving from the concerned department. This is their own, my lord, sworn affidavit.
What is the date of this affidavit?
November 24.
November 24. My lord, first December 2024.
11th December.
And if your lordship kindly takes, my lord, previous pages on their admission, they have, my lord, kindly sees the, my lord, the letter written by them, my lord, dated 25th November 2025. Just after, my lord, the report, my lord, dated, my lord, 25th November 2025, letter dated. Has your lordship got it? My lord, kindly see, my lord, penultimate paragraph. Has your lordship, these sentences we are making?
Yes.
We are making every possible effort to complete all required formalities at the earliest. Therefore, we sincerely request you kindly grant us one final extension till 25th to 2026. So that we may complete the occupancy change and obtain the fire energy. Milord, on their own asking, that date has been fixed. Page 70, Milord, I have just shown to your lordship, Milord. Thereafter, your lordship kindly sees, Milord, our written communication dated 18th November 2025. This is a response letter to them.
Yes.
It is, Milord, third paragraph. It is noted that you have submitted the above request prior to the effective date of suspension, seeking continuation of all services except the IPD services. However, in accordance with section such and such, every clinical establishment must comply with all prescribed conditions of registration and operation of any service after suspension can only be examined post commencement of suspension period based on the prevailing circumstances, statutory compliance status.
Yes.
Therefore, your prayer for continuation of the session may be examined only after the suspension order comes into force and subject to a review of circumstances, compliance obligations, and statutory requirements under the CE Act and rules. Beloved, they themselves, beloved, asserted they with sworn affidavit and also in their own letter, beloved, they said that within the 25th February 2026, they would, beloved, procure the, beloved, statutory mandatory, beloved, fire license, no objection certificate from the fire department to us. Beloved, this letter has been issued only, beloved, in the interest of the larger public interest or also, beloved, the patient's safety. Beloved, your lordship kindly remembers fire broke out at HON'BLE hospital, beloved, several casualties were there. So, beloved, this time we would be very strict, beloved.
Yes.
Well, when first I was issued with a clinical exploration license in 2023 based on all the documents. Thereafter, on that issuing license, they issued a condition that you have to obtain the fire note. The fire department came to our hospital that I have shown, my lord, at page that they have issued page 98 that they have taken, we are fine. Thereafter, my lord, the fire department was to issue a recommendation. What are the things you are required to be? We are required to do, my lord. Thereafter, my lord, if your lordship kindly comes to page 64, whether there is any ill motive or malpractice on my part. Now, on the contrary, my lord, I have been sincere and diligent. Page 64. Kindly see, my lord, I have applied. This is my application number to the dear so my lord. My lord, for any objection, this is in respect of kindly conduct the recommend. Thereafter, first at page 65, the date. Thereafter,
No, it's correct. It's correct. See, you applied, there is no denial. But unless and until you will not comply with the provisions of the law, you are not having all the certificates, even the fire safety certificate. Who will take the responsibility? You are running the nursing home, clinical establishment.
I am bow down to your lordship, but with deepest of respect. My
Yes,
lord,
yes.
this is not a fire certificate. Why? My lord, whether I have fire clearance or not, that I have. Kindly come to 30th January, my lord, 2026.
Page?
At page, my lord, 76. My lord, this is what I am required to comply. These are the recommendations which I am required to comply.
Correct.
That the, my lord, after the inspection. So, my lord, the health department, considering that I have the fire safety norms, issued me the license. Otherwise, they would not have issued me the license. These are the additional 50 recommendations which I am required to do, and I will do only after, my lord, those recommendations are being issued to me. Unless the recommendations are issued to me, my lord, I cannot add. They have been issued only on January 2026 or 30th of January. And immediately thereafter, my lord, I issued a work order for compliance of all these recommendations. I have an exact page 81. I have issued the work order. Now, my lord, I wrote to the authorities that the recommendations have been given. You give me another 4-5 months time, we will comply with the recommendation. Now, my lord, even after this, if I cannot do this, if I cannot comply with the recommendations, my lord, they are justified to cancel.
The last 3 years they are
Please,
setting
my
these
lord,
things.
please.
Yes, yes, continue.
My lord, they are justified to cut. My lord, from 2023, I am working with a fire license. Not that I do not have one. At page 98, I have a fire license. I am admitting that I gave them a affidavit that I will provide the comply with all the recommendations, but only after the recommendations are being issued to me, I can comply, my lord. Unless and until the recommendations are issued, I cannot. And my lord, they have been issuing this fire license from 2023. If, my lord, I am not entitled to the for the clinical establishment license to continue with the hospital, my lord, in the first place, the CMOH would not have issued me the license. They are only saying, I have issued the license considering all other fire safety, but you have to comply with the certificate of the fire department and all the recommendations have been completed. My recommendations have been issued to me, my lord, only on 30th of January. I have specifically given, I have pleaded, even if an inspection is done, I have no problem, my lord, that I have all the safety norms, only these additional recommendations of staircase, my lord, road width. This has nothing to do with internal fire management, my lord. Only additional.
Where is your fire NOC?
Fire NOC, my lord. This is the at page 98, my lord. This is what is given, my lord.
Where is the fire NOC?
Page 98.
Page 98.
My lord, FSR obtained, and I have also have.
It's a checklist. It's a checklist. After the checklist, the authority has to give the certificate.
See the first column. FSR, FSC obtained or not. Kindly see what is the A, FAR, FSR or whether.
Show me.
It is written here. It is
Not
it is
written.
department.
So, you are having some establishment. You have applied for grant of license. License is granted subject to fulfillment of sub-condition. One of the condition is the fire safety certificate. Correct, because you are running the clinical establishment. Fire safety, this is what you are relying upon, that you are relying upon with regard to the inspection, which you have shown to the authority who has inspected the premises in question, and he has written that. Show me where is your certificate.
My lord, serial number 1.
Yes, I have seen.
Is seen FSR oblique FSC obtained or not. This
Correct.
is the query. My lord, observation is A, and the memo number is given.
That's why, where is your certificate? You might have been having. Page 76.
My lord, kindly consider.
Page 76 is the latest, the recommendation.
Kindly consider the memo number and everything. That is the license. You have sent, you have issued the license. you comply with the additional recommendation. My lord, this is how it is not. My lord, kindly reconcile the memo numbers, my lord. It is said yes, they have issued it with the additional recommendation. We are issuing it, but you comply with the additional recommendation. I want, my lord, kindly give me 3 months time so that I can comply with this recommendation. My lord, kindly see the memo numbers.
Memo number continue because once the file has been opened, that will continue. The file will not, number will not change.
No, my lord.
If you made an application, your application will go in the same file, sir.
Not an application, only one for my.
How this number will come? Once you made an application, it will go to the. I will teach you. It will go to the dispatch section. Dispatch section will send to the authority, and authority will open the file. When the file will open, there will be a number of the file for the identification. Whenever your case will proceed from that file number, the case will be continued. So you cannot say yes, this is a file number. It is continued. So then fire safety, it is not a the whole time. Once the fire certificate is for a period of 1 year, 2 years, 6 months, whatever it is, then it has to be extended from, because today you are having the clinical establishment of two rooms. Tomorrow you will extend the 15 rooms. So that has to be extended. Then
only one humble reply, my lord. This is not a file number, my lord. With deepest of respect, my lord. It is seen, my lord. Kindly see whether you have obtained the fire safety recommendation.
yes, you show me why you're not obtaining the certificate. Where is the certificate?
That is I am showing, my lord. Kindly see the observation. Yes, and they have given the memo number. This is not the file number. They have given the memo number that I have. Now, my lord, page 76 is not the file number. It is that memo number that this is the certificate. May I read, my lord, at subject? From subject, my lord, read from page 76.
Yes.
My lord, subject, revised fire safety recommendations. Revised. That means, my lord, it was already revised fire safety recommendations for addition or alteration and change of occupancy of an existing construction.
Correct.
Yes, my lord. Now this has been issued. That if we suppose that initially I had one, this is a revised recommendation.
Whether the fire, you have made a party to the fire safety.
Yes.
Where is that?
My lord, respondent
number.
Yes. 6 and
Who is appearing? You are appearing.
We are also appealing.
You are appearing. All. Yes.
My lord, now I am.
So he is not having the fire safety.
No, not at all. Apart from that, I take the.
Sorry, sir.
My lord, only one thing I need.
Point of maintainability.
You are not having all the. Yeah. I can only pass an order if you comply with the all the.
There is an appellate authority in the statute. Kindly section 26. Your lordship can
complete.
Lordship can
26.
What you will
structure.
You are not having all the documents.
26. Section 26. Section 26, my lord.
My lord, it has just fallen from your lordship.
If he is agreed by an order of the my lord,
appellate authority.
yes, he can raise all these points there, my lord.
Only one, it has fallen from your lordship that only if I comply with the recommendation, my license will be renewed.
No, they will take appropriate steps.
My lord, this is exactly, my lord, what I want, my lord. Kindly hear me for 30 seconds. I want that. These are the recommendations. Kindly give me 3 months time. I will comply.
But no, you will not. You will not run the your clinical establishment.
There are already existing patients.
Maybe, but the court. How the court and the authority will take the risk?
I will admit no new patients, but there are no. What these patients will go, my lord. I will not admit no new patients.
No.
That direction also.
Patient details.
That direction is there, my lord. That direction is there.
What are the patients, my lord? I will admit no new patients. Well, what about the existing patients, my lord?
Maybe release it if you are not a.
Dear my lord, ICU and emergency. Government take
How many beds you are having? Huh?
26.
Then you release it.
My lord, dear emergency patient.
Emergency patient without the NOC of the fire safety.
My lord, let government take that.
Can I call your owner here now, and I will direct the police authorities registered a case against you.
My lord, only one thing, let the government take one responsibility of shifting those present. If I release them, my lord, then my lord, something will happen. Let the government shift them to other hospitals.
Have you informed the patients that you are not having the fire safety
before taking admission?
So I will direct the authority to paste this cancellation order in the in your premises.
January I have only get those. My lord.
So
This is not my fault, my lord.
What fault? 2023, you're writing to the authority?
I have applied every time, kindly recommend. They have recommended on 30th of January.
Sorry, sir, it is the public interest.
After compliance, it may be renewed.
That can be done, but now that the authority will see.
Only one thing kindly consider. From 2023, I applied before the Department of Fire. You kindly come and recommend. They came only in January 2023.
But you have not complied with. What can be done?
My lord, 50 recommendations in 25 days. My lord, it is building a staircase, 3 staircases in.
My lord, they have fixed the date, my lord, on 25th February 2026. Within that period of time, they would provide, my lord, fire license.
My lord, one thing. On January 30th.
So the affidavit is there, my lord.
25 days, my lord, building 3 staircases and widening the road, my lord. It is not.
From last 3 years, it is happening, my lord.
My lord, but the recommendations came only in January 30, 2026. My lord, only give me some time to comply with these recommendations.
The petitioner has filed the present writ application challenging, not challenging, praying for setting aside / modifying the memo number TMOH within bracket SPG/CE/8981 dated 1st of December 2025, wherein the Chief Medical Officer of Health, South 24 Pargana, directed the petitioner to submit the valid fire NOC issued by the competent authority by 25th of February 2026. 2026. It was further informed that no further extension of time shall be granted under any circumstances. The Chief Medical Officer also directed the petitioner to comply the same within the stipulated period, failing which the license issued to the petitioner, which will automatically cancelled. And counsel for the petitioner submit that the petitioner submit that in the year on 13th of January 2025, the Chief Medical Officer of Health issued the license to the petitioner for running the clinical establishment with effect from 2/2/2024 to 1st of February 2027. 1st February 20. The petitioner submit that the petitioner has requested and the respondent authorities only on 30 January 2026. 30 January 2026 has communicated the recommendation for addition of the alteration of change of occupancy of an existing construction G+4 storied institutional building in the name and style of Arati Hospital, a unit of Samrati Health Care Private Limited. He submit that in the said recommendation, there are several recommendations has been given, and on receipt of the said recommendation, the petitioner has awarded the work to the safety enterprises so that the petitioner can provide all the certificates as per the recommendation. Without considering that the petitioner has already appointed the authority for complete the recommendation of the as issued by the authorities, but in the meantime, the authorities have issued the said order. He further submit that if the further submit that if the petitioner is not allowed to run the clinical establishment, comma, the the patients who have been admitted in the hospital will be badly prejudiced. He further submit that if at this stage, if the court is not allowed the petitioner to continue this at clinical establishment, but he prays for allow the petitioner only to run the clinical establishment on temporary basis, but the petitioner will not only for the outdoor patient, and the petitioner will not admit any patient as indoor patient till the recommendation is not been completed. Learned Counsel appearing for the state has filed a written report wherein it reveals that the clinic establishment of the petitioner was initially granted, and license for the clinical establishment of the petitioner was granted subject to compliance with the statutory conditions prescribed under section 9 within bracket 1 of the Clinical Establishment Act, read with rule 7 within bracket 1 within bracket 7(2) of the West Bengal Clinical Establishment Registration Regulation and Transparency Rules 2017, including the submission of the valid fire objection certificate. He submitted that at the time of issuance of the license, the petitioner has submitted an undertaking that he will obtain the fire NOC within 6 months from the date of issuance of the license. In the report, it is further reveals that time and again, the respondent authorities requested the petitioner to provide the NOC, but the petitioner has given several undertakings, but till date the NOC has not been provided. And as such, the authorities have issued this notice, issued the impugn notice. Until Learned Counsel for the respective parties peruse the materials on record. This court find that the petitioner has obtained the license of the clinical establishment with the condition that the petitioner will comply with all the provisions as prescribed under law. After the issuance of license, the petitioner has also filed an affidavit. Giving an undertaking that he will submit the fire NOC immediately within bracket maximum within 4 months to the licensing authority on receiving from the concerned department. Police, in spite of this undertaking submitted by the petitioner, the petitioner has not furnished the NOC, fire NOC from the concerned authority. Full stop. The respondent authorities have also issued the so-called notice upon the petitioner, and personal hearing was also conducted, but the petitioner failed to comply with the provisions of section 9 within bracket 1 of the Act, read with rule 7(1) within bracket 7(2) of the West Bengal Clinical Establishment within bracket Registration and Regulation and Transparency Rule 2017. Full stop. Learned Counsel for the full stop. This court find that on 30 January 2026, the West Bengal Fire and Emergency Service, the Director, West Bengal Fire and Emergency Services has issued a letter to the petitioner, directing the petitioner to obtain on compliance of all the fire and life safety recommendations, to approach the concerned authorities for necessary inspection and testing of the installation. And after the installation, after completion of the all work, comma, if the authority will satisfied the work, satisfied, comma, appropriate certificate, fire safety certificate will be issued to the petitioner with regard to the premises in question. Full stop. Considering the above, this court find that the license was issued to the petitioner with the condition that the petitioner will comply with all the provisions of law, and the petitioner also given an affidavit by way of an undertaking that the petitioner will furnish the fire NOC within 6 months. But till date, the petitioner has not furnished the NOC. Full stop. Considering the above, this court, this court also find that on 30th January 2026, the Director Fire Safety, the West Bengal Fire and Emergency Services issued the recommendation to the petitioner. Accordingly, the petitioner is directed to comply with the recommendation in terms of the letter dated 30th January 2026. How much time you will complete this? Complete within a period of 3 months. If the petitioner comply with the recommendation in terms of the 30th January 2026, and the petitioner obtain the appropriate certificate from the Director West Bengal Fire and Emergency Services, the petitioner shall submit this certificate to the respondent number, Principal Secretary. To the respondent number 3, that is the Chief Medical Officer of Health, and the respondent number 3 shall consider the request of the petitioner after considering the certificate, if any, placed by the petitioner, and will pass appropriate order in accordance within. Full stop. It is made clear that that the petitioner is not having the prior license and other safety measures to run the clinical establishment, this court is not inclined to pass any order by allowing the petitioner to continue the clinical establishment till the recommendation is completed by the petitioner in terms of the letter dated 30th January 2026.
After I comply with all the recommendations, I will speak to the
That's why then the respondent number 3 will consider.
Department should kindly fix, otherwise they will be pending for another. Kindly give some so that they will not.
I have directed you will complete this within 3 months. If the fire safety authority find that the petitioner has completed all the work, the fire safety authority shall issue the certificate with the satisfaction of the authorities within a week thereafter, within 2 weeks thereafter. And if any certificate is produced by the petitioner to the respondent number 3, the respondent number 3 consider the same and will pass appropriate order for renewal of the license of the petitioner in accordance with law. Thank you. Report kept with the record.
My lord, my service may be kept with. Service.
Affidavit service and the report be kept with the report.
My lord, deeply honored. My lord, since the matter is over, my lord, I'm so grateful, my lord, at least your lordship has accommodated me in hearing the matter.
I am trying to accommodate all of you, but if you
and again, my lord, on behalf of whatever.
Okay, no problem. That matter is over.
We are apologizing.
Thank you.
Line 17, I'm appealing for respondent number 4 and 5, HDFC Bank.
Yes.
Well, the HDFC really doesn't have any role to play in this.
What is the prayer?
My prayer, I'll just quickly indicate, I'll take 1 minute's time. Well, there's a notification. This has nothing to do with SAFAC. I'll just clarify that right at the beginning. The question I know will fall from my lord. I'm clarifying that right at the beginning.
Once I open the page and I find the surface here.
Yes, but nothing to do. The action that I've challenged has nothing to do with SAFAC. Well, there is a notification of the DRT. This is under the Recovery of Deaths and Bankruptcy Act. Nothing to do with the SAFAC Act. Under that act, I'll show all these provisions if required at all. But there are notifications that can be issued, rules that can be made. According to one of the notifications, I indicate the jurisdiction for one DRT2, which is located in Calcutta, was decided.
On the basis of that notification, I file a SARFAESI application before the DRT.
What
Now,
is the notification?
The notification, I'll show you. I'll
What the notification says? I don't.
Notification only gives the territorial jurisdiction of all the DRTs.
Correct.
When the matter is, for example, for one district in West Bengal, then which DRT will it go to? That is the entire purport of it.
Correct.
There is nothing else except for that. Now, during that notification being in vogue, I come forward and file a SARFAESI application. The bank also files an application, an original application. These are both pending. Now, during the pendency of both these proceedings, there is another notification that comes out, post, my lord, the Shiliguri DRT being created. Now, this notification, the second one, what it does is, in modification of the earlier notification that I indicated, my lord, says that the territorial jurisdiction where my property was located, Birbhum district, the matters will have to be now filed before the Shiliguri DRT. This will no longer be before DRT.
Birbhum is Shiliguri.
No, Birbhum now is Shiliguri. I don't know why the difference is 2,000 kilometers. Birbhum is naturally closer to Calcutta, which is also one of the grounds I've taken. I don't know why it's gone to Shiliguri, but that is not even my challenge because I'm not challenging the notification at all. Now, based on the second notification, what the DRT does is unilaterally, the registrar DRT, because this is a part of the administrative function. This has nothing to do with the judicial function. Unilaterally, without putting me on notice, they transfer my case to DRT Shiliguri. My case, and this is not on facts at all, my case is only on 2 points. The first is it's an administrative function, so I must have had to be given an opportunity. Even if I concede I may not have been given an opportunity, the notification could not have had retrospective effect in the absence of the notification specifying the retrospective effect has been given. That is first principles. Any delegated legislation or legislation, unless and until it expressly says that it can give retrospective or retroactive effect, it cannot have retrospective effect. I'm carrying 4 judgments, but that's absolutely trite law. So when I file my application prior to the notification, when the territorial jurisdiction was with DRT2, then a subsequent notification cannot alter my position and send me to DRT Siliguri.
Okay, is it based on the section 6 of the general clauses?
Well, that is one bit of it. And also, my lord, under the Recovery of Debts and Bankruptcy Act, there is no power, my lord, which is granted for giving retrospective effect. I'm also equipped with the 4 judgments. But that's
where is the notification?
Yes, and I will indicate, my lord, the papers. Lordship kindly takes up, my lord, the first notification, which is at page number 172. 172 is the first notification. This 15th of March 2017.
Yes.
The Lordship kindly looks at, my lord, serial number. Well, this is
issued by the ministry.
Excellent. Serial number 2, my lord.
DRT2 Kolkata.
DRT2. The Lordship
all
looks at the
district
third.
of West Bengal except Kolkata city, district Howrah, Hooghly. What remains?
So this is, my lord, this is negative. So Birbhum goes to DRT2, which is why my filing could be possible. Everything except these districts. It's couched negatively. But so this is a residual clause. So Birbhum goes to DRT2. Shiliguri is not in existence. Now, Lordship, now post that, my lord, this is on 15th of March. Lordship will only make a note, my lord, my SARFAESI.
Who is appearing? Authority?
For respondent number 9, I am not even a party in the essay. I have nothing to
For abundant caution.
Who is the authority?
Authority should
This is a registrar. I've served them thrice. Served everybody thrice.
Okay, then what has happened?
Yes.
Union will also have.
So this is, so you are not coming under, you are coming under the.
I'm coming under DRT2, serial number 2.
You are in Birbhum.
I'm in Birbhum district.
Correct.
Well, then Lordship will only make a note, my lord. I filed my SARFAESI application 14th of December 2018. When this notification was in vogue.
You filed
on 14th of December. I'll indicate that from my SARFAESI application.
Okay.
14th of December. Now, Lordship will kindly take up 173 once. I'll just clarify, my lord, for abundant caution. But I'm not challenging this notification. This is, my lord, dated 16th of December 2025.
25.
Yes. Lordship will kindly turn over, my lord, to 174. Now, this, my lord, modifies the previous notification.
All district of West Bengal except Kolkata city. Polling substituted.
Now, Birbhum has been added.
All district of West Bengal except Kolkata city, district of Howrah, Hooghly, Darjeeling, Jalpaiguri, Coach Bihar, Murshidabad, Again, you are not there.
No, I'm there, my lord. Birbhum.
Where it is?
My lord, Lordship looks at serial number 1.
Ah.
All districts of West Bengal except Kolkata city.
Okay.
Yes,
Which
right
is
after
not there,
Murshidabad.
except.
Right after Murshidabad.
Correct.
And before Alipurduar.
Correct.
So now this notification is on the basis of which the transfer has happened. But if your lordship peruses the remainder of the notification, it ends
No.
on the same page.
One, again the serial number 2 of column 4 of the entry. Entries in the following entries shall be substituted. 2 and 4.
Roman 1 and 3 are relevant to me.
Correct. So all district of West Bengal.
Yes.
Correct.
Yes. And
except Birbhum is also there. So
Birbhum is also there now from 25. Now lordship looks at serial number 3 on the same page at 174.
Again serial number 3, dear.
No, Roman 3 again serial number 4. In column this was Shiliguri. Lordship will see now Birbhum has gone to Shiliguri district. Shiliguri DRT. Birbhum district. Darjeeling, Jalpaiguri, Kuchbihar, Uttar Dinajpur, Dakshin Dinajpur, Malda, Murshidabad, Birbhum.
Where you are reading?
Lordship is at bottom of the page, at 174.
Darjeeling, Jalpaiguri, Kuchbihar, Uttar Dinajpur, Dakshin Dinajpur, Malda, Murshidabad, Birbhum.
Birbhum.
Correct.
So now Birbhum goes from DRT 2 to DRT Shiliguri. Serial number 4 here is DRT Shiliguri at 172.
Correct.
So the effect of this is that whatever will be the new surface application, the OA application, whatever is filed before the DRT.
Prior to where you were there? 1 and 2.
I was at serial number 2 at 172 because I filed my application as Lordship looks at serial number 4 at 172. That is DRT Shiliguri.
Birbhum has given an accept. Okay.
Yes. And serial number 4, Birbhum is not there at page 172.
Correct.
Because it's a DRT2, not a DRT Shiliguri. Now, by virtue of the 2025 notification.
So you gone to the.
I have not been sent. The jurisdiction has been sent.
Correct.
But only with prospective effect. Because I'll show Malad 2 judgments.
So this is the way. Where is your application?
Yes. Now my surface application, Malad, is at Malad. She will kindly take up page number 31 of my writ application. The date of filing, Malad, will find from
31.
31 is where my surface application starts.
2018 you filed.
2018 I filed. So prior to the 2025 notification.
Then where is the difficulty now?
No, now they've transferred. Now Lordship kindly.
Where is the transfer order?
Yes, transfer order Malad comes. I'll indicate before that Lordship takes a 175 once. I look at the server. This is without notice. I received the notice Malad recently after filing of the writ petition. Lordship looks at 175. My surface application, there's a new case number which is given.
TSA 106.
Now this is gone to
new 234.
Yes.
Yes.
Lordship allows me to place reliance on one document. This has come by way of speed post filing of my writ petition. This has been received on 18th of February 2026. This is an order that's been passed there. The 14th of January is the order. Receive the record of the essay number so-and-so from the learned DRT to Kolkata in view of the Gazette notification dated so-and-so 16th of December 25 regarding reallocation of jurisdiction of the district of Kalimpong, Alipurduar and Birbhum in the state of West Bengal to DRT Shiliguri from DRT to Kolkata. The case record contains the list of documents as mentioned in the checklist prepared by this tribunal. The case is renumbered as TSA 106 of 26. And the instant matter was filed, but the matter has been made returnable on 27th. Nothing has happened. I've received this post 27th. I'm told, I'm informed, the next date, is in the first week of March.
Yes.
Now, before I indicate, the judgments, I am, 60 years of age, I'm suffering. Several medical ailments have annexed all these documents. I don't want to unnecessarily trouble your lordship with all the papers. Difficulty is, today, the difference between where I stay, which is Shantiniketan, Birbhum district, and Kolkata DRT.
What is the stage of your case?
Well, it's at the, I think affidavits have been filed by them. It's at the stage, your lordship knows, applications are filed. I want to be physically present there in my hearings every day. Now, Shiliguri, from Kolkata is approximately 9 hours. 9-10 hours. Now, that's a night journey. Lordship will now allow me to place reliance on 2 judgments. Actually 3, my lord. Administrative decision I'm not required to show to your lordship anymore. I'll just indicate, my lord, that 8 Excise Commission Act. No, before that, I'll show a division bench of the Calcutta High Court itself. Wait, Justice Obruch of
Give. First.
Chief kindly directly takes up two paragraphs only, paragraph 6 and paragraph 11. 6
Unions of India, sir, I have brought instructions. Unions of India.
You are the main party.
Yes.
He's no
Union of India.
Yes.
Yes.
no, their notification I'm not challenging. The registrar is the one who's caused the transfer.
No, they have not challenged, but they have
You
to
have
assist the court
instructions.
whether the notification
Absolutely, absolutely.
prospective effect or prospective
Absolutely.
effect.
Yes. Chief Luke said, my lord.
Paragraph 6.
6, my lord. Per contra, Mr. Banerjee. Mr. Banerjee, learned senior advocate, assisted by so-and-so learned advocate, appearing for the writ petitioner respondent herein, submits that there is no infirmity in the order impugned, and as such, no interference is called for in the present appeal. The allotment has been quashed, applying the land allotment policy notified by the government of West Bengal on 26th of December 2012. Admittedly, the said notification is prospective in nature. An administrative decision affecting the rights of individuals cannot have any retrospective effect. In support of such contention, reliance has been placed upon the delivered judgment of the coordinate bench in so and so. Now, Lordship takes up paragraph 11 once.
Yes.
The scope of adjudication before the learned single judge was thus restricted to the issue as to whether the appellants could have applied the provisions of the notification dated 26th of December 2012 retrospectively. The arguments advanced on behalf of the appellants as regards application of the provisions of the land policy notified vide memo dated 26th of December 2012, in our opinion, was rightly discounted by the learned single judge, since the said notification had not been given any retrospective effect and could not have been taken into account for cancellation of allotment. This is all that I intend to show. Now, Lordship allows me to place reliance, my lord, on Lord, this is 2021 10 SCC 210. Lordship directly, my lord, takes up paragraph 16, which is appearing, my lord, at page number 218. The page number, my lord, is of the citation given on the top left-hand corner of the page.
Yes.
Paragraph 16. There is profusion of judicial authority on the proposition that a rule or law cannot be construed as retrospective unless it expresses a clear or manifest intention to the contrary. In CIT versus so-and-so, I'll just indicate that portion of the quoted part. Of the various rules guiding how a legislation has to be interpreted, one established rule is that unless a contrary intention appears, a legislation is presumed not to be intended to have a retrospective operation. The idea behind the rule is that a current law should govern current activities. Law passed today cannot apply to the events of the past. If we do something today, we do it keeping in view the law of today and in force, and not tomorrow's backward adjustment of it. Our belief in the nature of the law is founded on the bedrock that every human being is entitled to arrange his affairs by relying on the existing law and should not find that his plans have been retrospectively upset. This principle of law is known as lex I'm overlooking all of the. As was observed in Phillips versus Iyer, a retrospective legislation is contrary to the general principle that legislation by which the conduct of mankind is to be regulated, when introduced for the first time to deal with future acts, ought not to change the character of past transactions carried on upon the faith of the then existing law. The obvious basis of the principle against retrospectivity is the principle of fairness, which must be the basis of every legal rule, as was observed in the case of so-and-so. The legislation which modified accrued rights on which impose obligations or impose new duties or attach a new disability have to be treated as prospective unless the legislative intent is clearly to give the enactment a retrospective effect. Unless the legislation is for the purpose of supplying an obvious omission in a former legislation or to explain a former legislation. We do not note.
Next.
Lordship 17 also I wanted to show once, may I, my lord, with my lord's permission.
That's same CIT.
Yes, it is same, my lord. Lordship looks at, my lord, Kanak exports once. Now this is 2016, 2 SCC 226. Only one paragraph I'll show. It's slightly hefty, but I'll only show, my lord, one paragraph.
Paragraph?
6. Paragraph 113.
113.
113, my lord. I'll just indicate the page number, my lord.
Yes.
Yes, 113. We may in the first instance make this legal proposition clear that a delegated or subordinate legislation can only be prospective and not retrospective unless the rule-making authority has been vested with powers under a statute to make rules with retrospective effect. In the present case, Section 5 of the Act does not give any such power specifically to the central government to make rules retrospective. No doubt, this section confers powers upon the central government to amend the policy which had been framed under the aforesaid provision. However, that by itself would not mean that such a provision empowers the government to do so retrospectively. This legal proposition is rightly discussed by the Bombay High Court in the impugned judgment in the following words. 26. We are unable to accept the submission of the learned advocate Solicitor General. The word amend does not give power to make amendment retrospectively. If it is used in relation to the powers and make a piece of delegated legislation, the connotation of the word amend, when it is used for the exercise of powers by a legislature, cannot be pressed to construe the word amend in relation to powers to make delegated legislation. In this regard, the following observation, this is the same proposition, I don't want to waste my lord's time. Same thing given. Last judgment that I'll indicate, my lord. No, my lord, these are the only three. The last one was on the point of administrative action. That I'm not required to. Only one provision that I'll show, my lord, from the Recovery of Debts Act. This is the establishment. Two sections I'll show. Lordship kindly takes up section 3 once first. Well, this is when the DRT is established. Establishment of the tribunal.
Yes.
1. The central government shall by notification establish one or more tribunals to be known as the Debt Recovery Tribunal to exercise the jurisdiction, powers and authority conferred on such tribunal by or under the order. So this has to be by way of a notification. Now, Lordship will kindly take up section 36 once.
No, the central government shall notification establish one or more tribunal and known to be debt recovery tribunal.
This is not only
the notification establish a number of debt recovery tribunal and benches necessary. Yeah, exercise the jurisdiction power under the authority of
Yes, so no retrospective power given under the main statute.
Yes.
Now, another section, 36, power to make rules. I'll just show 36, 1, 2, and 3. So, Lordship looks at 1 once. The central government may, by notification, make rules to carry out the provisions of this act. So, power of making notification is governed by the main statute itself.
Correct.
Power 2, if your Lordship looks at subsection 2, no retrospective given in any of them. A, B, C, D, no power of transfer suo motu has been given.
Yes.
The reason I say this is only to emphasize that the power is dehoes the statute. Now, Lordship looks at subsection 3.
Yes.
Every notification issued under subsection 4 of section 1, section 3 and section 8, and every rule made by the central government under this act shall be laid as soon as may be after it is made before each House of Parliament, which it is in session for the total period of 30 days, which may be comprised in one session or in 2 or more successive sessions, and before the expiry of the session, immediately following the session of the successive session aforesaid. Both houses agree in making any modification in the notification or rule, or both houses agree that the notification or rule should not be issued or made, the notification or rule shall thereafter have effect only in such modified form or be of no effect as the case may be. So, however, that such modification or annulment shall be without prejudice to the validity of anything previously done. So, even the Parliament does not have power to give it retrospective effect anymore. Unless section 3 is now amended or the act itself is amended. Only, and for the last point that I want to make, I'll rest my case.
Yet the act is not amended. Yet government makes the following amendment in the notification,
Yes.
not the act.
No.
The
Lordship is right. Lordship is absolutely right.
Not the act or not the rules. It is only the notification has been amended, the jurisdiction has been changed.
Yeah, the only reason I say this, my lord, is because today, from whatever the judgments...
36 will not hear.
No, the reason I say make that submission, I know Lordship is otherwise, my lord, with me on the point that it cannot be given retrospective. The only additional point, my lord, even at my peril, I make that submission, is because today, the power of making notification under section 36 Now, unless section 36, which is a part of the statute, provides that such notifications which are promulgated or which are otherwise legislated can have retrospective effect.
That is different.
Yeah, that's the only point. I'm not making any other point.
Different thing.
That's the only point.
That is the law, unless it has, because even though judgments, we are passing the judgment. Unless we not pass an order
Clarify
which affect retrospective effect, so it has to be
the clarification. Same with that wing of the state also, which is the
so
legislature.
it cannot be. So today I pass an on judgment. So earlier, whatever the benefit you got, you cannot say that has to be taken back.
Absolutely. That I bow down. But as an officer,
Yes.
I wanted to indicate that only one portion, my lord, section 5 capital A of the SARFACI Act, if your lordship takes up, my lord, once, but I have the act, your lordship. Can rely on this. Well, this I'm not required to show, but again, for abundant caution, I am showing this. This is the only provision under the statute, my lord. They have not exercised this power. I'll just clarify that. But I'm saying even if I take the case higher, section 5 capital A, transfer of, I'm sorry, my lord.
Transfer
of pending applications to any one of the debt recovery tribunals in certain cases. If a financial asset of a borrower acquired by an asset reconstruction company comprised of secured assets of more than one bank or financial institution for recovery of which such banks or financial institution has been filed application before 2 or more debt recovery tribunals, the asset reconstruction company may file an application to the appellate tribunal having jurisdiction over any of such tribunals in which such applications are pending for transfer of all pending applications to any one of the DRTs. On receipt of such application for transfer of all pending applications, any subsection 1, the appellate tribunal may, after giving the parties to the application an opportunity of being heard, pass an order for transfer of pending.
As like 24 of
Yes,
the CPC.
Lordship will pause here for once, my lord. The entire gamut of all the legislations does not give any suo moto power of transfer.
Correct.
That's my point, my lord. I don't want to make any other submission. I rest my case.
I don't have any.
You are appearing for?
For respondent number 9, Muller, I'm not even a party in the essay.
Hmm.
I really have nothing to say in this writ petition, Muller. Neither does my respondent 9. I'm the assignee of, I'm the secured creditor, Muller. I have been assigned the debt in respect of the petitioner. I am the secured creditor. I have no role. I have not yet been impleaded in his essay. The essay is filed by my learned friend. I am not a party there as well. They've pleaded in the writ petition. They're taking steps to implead me. I have no role whatsoever to play, Muller.
Yes.
Clearance of failure, sir. I have no instructions. What I am saying.
I am applying for HDFC Bank. I have assigned my respondent number 9. Cannot be. As a primary respondent, I don't know whether they've been served or not.
They've been served. I'm carrying the affidavit of service.
Where is the affidavit?
The original affidavit of service on record.
Petitioner has filed the affidavit of service. Let us send it to the record. In spite of service of notice, none appears on behalf of the respondent number. That's number 2 and 3. 2 and 3.
Yes.
Learned counsel for the petition has concluded his argument. This court find that one opportunity should be given to the respondent number 2 and 3 to appear in the matter. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 12th of March 2026 under the same heading. The petition is directed to inform the next date of hearing to the respondent number 2 and 3 and to file the affidavit of service on the next date fixed. It is made clear that on the next date fix, in spite of receipt of the notice, if the respondent number 1, 2 and 3 will not appear before this court, the writ petition will be disposed of in their absence.
But 12th Lordship is kept it. Matters returnable. The SARFACI proceeding is returnable in Shiliguri on the 3rd or the 4th. My applications, I can't ask for a stay. I'm only saying, Lord, if there can be an interim measure because they are not appearing and they have done it without putting me on notice. Lordship, till the hearing of this application, this could be transferred back to DRT 2.
That possibly cannot be.
Has handed over a order sheet issued by order sheet. A order passed by the registrar DRT Siliguri dated 14th of January 2026, wherein it is found that the case of the petitioner is being placed before the DRT Siliguri according full stop. The petitioner has accord full stop. As none appears on behalf of the defend number respond number 2 and 3. Accordingly, the respond number 2 and 3 is directed not to proceed any further in respect of the TSA 106 of 2026 until further order.
But the SARTC application the same is filed by me. But today that would virtually operate as a C. So what I was seeking was till the hearing of this, because I don't have any further submissions to make. Till the hearing and disposal of my writ petition, let them transfer it back to DRT.
Final.
How it can be?
That's a final relief, that's being sought.
In that case,
the final relief.
Fix the matter, at some time.
Yes, and I think the
time.
No time, or urgent motion it will come.
I'll not make
So
any
you don't want this order, stay order you don't want.
No, if this will work.
It is in last one order. Communicate and file the affidavit of service. Huh?
Obliged, sir.
Very well, could I at least get this? I'll be a dependency of this will allow me to pray for an adjournment.
You filed it. Take the order.
Obliged.
Yes, next.
18, my lord.
80 mine appearing for the.
I have for the petitioner.
Lordship, on the last occasion.
Respond number 3 on last occasion, Lordship directed me to take
Yes.
some instructions, my lord.
What instructions
My lord, we can allow, my lord. Only thing, my lord, the director of the National Testing Agency is there online. Later on, some complication may arise, my lord. He can apprise your lordship. Mr. Sahu, you can.
Yes, you are the director. Please unmute.
Please unmute yourself.
Yes, yes, Lordship. Thank you for giving me opportunity to address on this question. The petitioner in his writ petition, page number 13.
Yes.
One of the relief sought from the Honorable my Lordship is that D. It says that NTA may be directed to allow the petitioner to submit his application form for NEET UG 2026 as Abhirup Kundu. So in this regard, our humble submission is that, Lordship, so far as application norms and procedure is concerned for NEET UG 2026, the candidates do fill up their names and other particulars in the form themselves. NTA does neither add anything nor remove anything in the application. So therefore, the candidate is free to mention whatever name he fits thinks proper for him as the candidate for NEET UG. So only thing is that at the time of admission, when documents should be verified by counseling authorities, the central as well as state, that time he may have to show the documents. In that case, appropriate order, he may seek further indulgence of this honorable court or directly approach to the counseling authority later stage after the declaration of result, Lordship. Whatever any candidate submits in the application, his admit card is issued accordingly. His scorecard would also be issued accordingly, Lordship. His result data would also be provided to the counseling authorities accordingly.
Okay.
If he is filling up Abhirup Kundu, then in his admit card also his name would figure as Abhirup Kundu, and in his scorecard it would appear as Abhirup Kundu. Only at the time of going to the examination center, he may carry a certified copy of his class 12 10 board certificate, just to prove that his name is Abhirup Kundu, because in the Aadhaar card perhaps some other name has crept in.
Yes.
Yes, Lordship.
So
basically,
I will direct you. You allow the petitioner to appear in the NTA examination in the name of the Shubhrup Kundu alias Abhirup Kundu.
Yes.
Shubhrup Kundu alias Abhirup Kundu, and in future, if they will, as per the notification, if they will correct the name, it can be accordingly. It can be considered by the authority.
By the other authorities, admission or counseling authorities in due course, Lordship.
Correct.
Absolutely, we have no objection, because we do not fill up any particular on behalf of the candidate. Candidate themselves, they do fill up the application form. Yes, Lordship.
I am not standing in the, but in that case, what you has to not press the other place. Where there's a
No,
date.
that's what I am not passing any further order. I will allow him. I will allow the NTA. This is
Response number 3.
3. Response number 3 to allow the petitioner register the name of the petitioner to appear in the NTA NIT examination in the name of Abhirup Kundu alias Abhirup Kundu. List of this is only, and she will appear, and he will be given liberty to apply for the change of the name in accordance with law. If in future the name will be changed, that will be corrected by the authority by the response number.
Small Indian. Document I sharing of a content in the earlier repetition of it. This is my only. I'm just skeptical about it. I'm just skeptical.
That way, I think serve the purpose. So if in future he will correct the name by way of a notification, then he will take appropriate steps automatically. Not major. Major, otherwise the father can apply.
Father is not there.
No, then you go to the then you go to the sessions session, the district judge, and obtain an order.
So for the mother's disappearance, it will be ended May 2000 of this year, 26.
7 years.
7 years.
7 years.
7 years.
Presumption.
Presumption as to date. That is the problem we are facing.
So then you can go to you have two options. Either you go to the guardianship or you go to the declaration.
In that, if I file an application for guardianship also, first thing I have to satisfy for the court that father and mother, who are the natural guardian, they are not
No, then you have to take 2 steps. First, you have to go to this section 7, read with, and section 12 for interim, and you have to file a suit for declaring your mother is passed away. Declaring that.
Declaring that
That is after 7 years.
After 7 years. That is the difficult.
No, then
But that I will do. Certainly I will.
The petitioner has filed the present writ application praying for a direction upon the authorities, specifically the Unique Identification Authority of India, to change the name of the petitioner in Aadhaar card as Abhirup Kundu in place of Shubhradeep Kundu, and to provide a fresh Aadhaar card in the name of Abhirup Kundu. Full stop. The petitioner father expired on.
Not expired.
But the father of the petitioner is missing since the year 2011, and the whereabout the mother is not known since 2019. The father is within the guardianship of is residing with the grandfather, maternal grandfather, paternal is residing with the maternal grandfather. Full stop. The main grievance of the petitioner is that the petitioner intend to. Who is the petitioner? Minor.
Minor.
The main grievance of the minor is that the intends to appear in the NEET examination, which is scheduled to be held in the month of May 2025, 2027, 2026, 2026. But the authorities, NTA authorities, are not accepting the form with regard to the correction of the name of the petitioner, the minor, in the Aadhaar card. Full stop. As per the direction passed by this court, the director of NTA and director within bracket legal NTA is present through virtual mode, and he submit that the NTA has no objection to allow the petitioner to appear in the NEET examination in the name of Shubhradeep Kundu alias Abhirup Kundu. Correct?
Lordship, we have never objected for him to file.
It is a submission I have recorded. It is a submission.
Yes, Lordship. Absolutely, we have no objection, Lordship. Whatever name he would prefer, comfortable, that may be permitted, Lordship.
No objection to allow the minors to appear in the NEET examination in the name of Shubhradeep Kundu alias Abhirup Kundu. He further submit that the NTA has never denied for registration of the name of the petitioner for partition for appearing in the NT examination in the name of Shubhadeep Kundu alias Abhirup. Full stop. It is the learned counsel for the petitioner further submit that the petitioner is minor. Further submit that what you have submitted.
All the documents as regards to my educational qualification.
No.
My name featured has been Abhirup Kundu.
Counsel for the petitioner submit that in all the documents, the name of the petitioner is recorded as Abhirup Kundu, but only in the birth certificate also. But in the birth certificate, the name of the minor is recorded as Subhradeep Kundu alias Abhirup Kundu, and in the Aadhaar card, the name of the petitioner is recorded as Subhradeep Kundu, care of Shikha Mandal. As such, the petitioner intend to correct the unique identification, correct the name of the petitioner in the Aadhaar card, but the authorities have not corrected the same. Then an advocate appearing for the 2 and 4 submit that unless and until the petitioner will not made the publication of correction of the name in the official gazette, it is not possible for the authority to correct the name of the minor in the Aadhaar card. And as such, she submit that if the petitioner will furnish the gazette notification by way gazette notification showing for correction of the name, the authority will act in accordance with. Heard the learned counsel for the respective parties. This parties, the director legal NTA has categorically submitted before this court. The NTA has never denied the petitioner for accepting the application for registration of his name for appearing in the NEET examination, commencing NEET examination for the year 2026 in the name of Subhradeep Kundu alias Abhirup Kundu. Accordingly, the petitioner is at liberty to apply for registration of her name to appear in the NEET examination for the year 2026. Full stop. As regard the correction of the name of the petitioner of the minor in the Aadhaar card, the petitioner is at liberty to make appropriate publication by way of notification, and if the notification is made for correction of the name of the petitioner as Abhirup Kundu instead of Subhradeep Kundu, the notification shall be furnished to the respondent number 2 and 4, and the respondent number 2 and 4 take appropriate step for correction of the name of the petitioner in the Aadhaar card. क्या बोला? Take appropriate step for correction of the name of the petitioner in the Aadhaar card as Abhirup Kundu instead of Subhradeep Kundu in terms of the notification. Yes, what?
Lordship, the last date is 8th of March. The petitioner should apply by that time online.
Apply बोला ना? Is liberty to file the form for apply. क्या बोला? Within the specified date fixed by the authority.
Thanks.
All the documents sharing name as Abhirup, and the petitioner be permitted to fill up his form as Abhirup. All testimonials and educational qualifications shows Abhirup. Otherwise, I have to upload some documents as regards to Subhradeep. I cannot upload. That is the problem.
Apply the petition given liberty to apply for registration of her name for appear in the NEET examination in the name of Abhirup Kundu, but the authority is directed to accept the birth certificate and the Aadhaar card which is in the name of Subhradeep Kundu.
Yes. That has not been carried out. We have not preferred any other.
The respondent number 3 and 4. 3 and 2 and 4. Submit that on earlier occasion, this court, by an order dated 27th of January 2026, has passed an order directing the authority to correct the name of the petitioner in the Aadhaar card, but the authorities could not able to correct the Aadhaar card due to non-completion of all formalities by publication of the name in the Gazette notification. Thus, the order dated so-and-so is modified by this order.
Yes,
Next. Origin side.
I appear for the petition. Led by Mr. Cordman and Mr. Corey.
টাইম চাইছিল জয়দীপের জন্য
না না কেউ টাইম চাইছে
না বলছে
একটু
নট টুডে করে দিলে বেটার
হ্যাঁ তা তো বটেই
Yes.
The election commission was supposed to answer all.
Yes, you are appearing, Mr. Mukherjee?
Yes.
তোমাদের বলা হয়ে গেছে
Yes.
পয়েন্টটা বলা
my lord, 4 points I want to take, my lord. First is, my lord, a very material fact has been suppressed. My lord, kindly, my lord, see, my lord, the averments, my lord, in the petition. My lord, paragraph 10. My lord, 10 to 12, my lord, at pages 15 and 16. The petitioner states that despite submitting a pre-bid query before the respondent number 1 within the specified time, the respondent authority simply sat tight over the matter, due to which the petitioner was constrained to send its employee to meet the respondent tendering authority to clarify the issues raised by the petitioner, wherein the petitioner was verbally assured that a corrigendum will be issued pertaining to the subject tender and further extension would be provided to all the intending bidders. Then 11, the petitioner states that the respondent authorities, vide a notice dated 20th February 2026, issued a corrigendum to the impugned tender being request for proposal so-and-so on 9 February, wherein none of the suggestions of the petitioner was taken into consideration and neither have extended the time period to submit the bid. In this regard, copy of corrigendum dated so-and-so. The petitioner states that it is germane to mention herein that the respondent authorities, despite receiving the pre-bid query, has not replied to the same by clarifying such queries, which clearly shows that they have intentionally did not pay any heed to the petitioner number 1's query, despite obligated to. Now, my lord, kindly have a look at that corrigendum once. Your lordship will find that at page 285, my lord. I've got it.
Yes.
Now, my lord, this is 20th February 2026.
Yes.
Now, my lord, corrigendum to e-tender dated so-and-so. This office invited so-and-so.
Yes.
Then, my lord, the in continuation of the resolution of the pre-bid meeting on 16 February 2026, in connection with e-tender so-and-so, for life, the following updation and clarification is issued and shall be treated as an integral part of the NIT surveillance system for so-and-so. So, my lord, the query which they had raised was with regard to clause 4.4a. Now, my lord, corrigendum deals with, my lord, 4.4b. My lord, para 4b, my lord, 4 is eligibility criteria. My lord, existing provision, your lordship sees. Item 2, page 32, eligibility criteria, para 4b. bidder should have executed at least 3 full. My lord, this is, I'm coming to this later.
Yes.
My lord, what he says is, if your lordship has a look at the query once, my lord, page 176. My lord, this is, my lord, their query. Kindly have a look, which relates to page 31. Kindly come to page 176. With reference to tender, I'm sorry, my lord, annexure P4. My lord, 13 February, with reference to tender so-and-so for live web streaming for selection of an agency by providing e-surveillance so-and-so, kindly find the attached tender document for your kind perusal. I hope the same is in order. Then, my lord, pre-bid query. Kindly have a look at the query and, my lord, suggestion for change. Kindly look at the left-hand column. My lord, it's
Yes.
the page 31, my
Yes.
lord, 4A.
Yes.
My lord, I'll come to this later when I deal with the merits. Now, what is important, my lord, what your lordship has not been told, that, my lord, queries had to be put in by a particular time. The notice inviting tender also gave the time for, my lord, a meeting, pre-bid meeting to be held where all queries will be discussed. Now, my lord, kindly have a look at the tender conditions at page, my lord, 60, my lord, 67, my lord. It starts. Kindly have a look at, my lord, item 6. My lord, one is, my lord, last date for submission. My lord, is for pre-bid queries, 14 February till 1700 hours.
Yes.
Pre-bid meeting, 16 February.
Yes.
And, my lord, item 9 is last date for submission of proposals.
21st.
And, my lord, 10 is opening of bids. Now, my lord, what your lordship has not been told, my lord, is that they attended the pre-bid meeting. First, my lord, kindly have a look at other side. Huh? বলেছে attend করেছে বলে? Where? In the petition? Oh, it's not mentioned in the petition, my lord. I don't know if it was argued, but, my lord, I'll take my learned friend's word for it that it was argued. Now, my lord, they attended the pre-bid meeting and, my lord, all was discussed and this amendment, my lord, was made by way of corrigenda. So, my,
They have argued, yes, pre-bid meeting was held, but they have not considered and passed this 285 as passed. This
yes.
is the submission.
Now, my lord, the important thing is they
Considered what they have proposed, that has
yes.
not been.
Now, my lord, my lord, it's not, my lord, an order. My lord, it is all bidders, my lord, who wish to, my lord,
Give all the
yes,
proposals.
my lord, their proposals are discussed and where changes have been felt appropriate, my lord, changes have been made. So, my lord, this is, my lord, the first point I wish to make. Now, my lord, the second point, my lord, is, my lord, kindly have a look, my lord, at, my lord, the query, my lord, which was now, my lord, kindly have a look at, my lord, page 176. Find out what all was argued.
Yes.
Now, my lord, page 177, their only grievance,
Counting center.
my lord, is with, my lord, clause A.
Yes.
Now, my lord, I do not know, my lord, if any grievances have made, my lord, with regard to other clauses.
They are only grievance with regard to this counting center, totaling in less census.
Yes.
And second is with regard to, and this is the main.
Yes. Now, my lord, as far as this is because all the other points which have been taken, my lord, are not, my lord, in the pre-bid query. They're quite happy with it. Now, this was the only, my lord, point taken. Now, my lord, what they say is, in effect, 2 points. My lord, one is, my lord, that these conditions, my lord, are such as to, my lord, set up an artificial barrier, my lord, towards, my lord, competition. And second, my lord, they are tailor-made to suit someone. Now, my lord, the second point first, my lord, there is no allegation, my lord, as to who, my lord, it has been tailor-made for. My lord, as on date,
my lord, 4 bids, my lord, have been submitted. My lord, there is, my lord, no case made out, my lord, in whose favor, my lord, it has been, my lord, tailor-made. Now, my lord, the second, in fact, my lord, it's completely, my lord, vague, my lord, in this regard. If your lordship looks at 2 averments, my lord, in the petition, your lordships will find, my lord, at paragraph 6, at page 10, my lord, page 10, para 6, upon coming to know there are some irregularity and illegality in the impugned tender condition, specifically clause 4.4, which palpably shows that such condition has been incorporated and has been tailor-made in order to cut out competition. Well, that's what I meant by artificial barrier and curtail participation. Yes. No, my lord, who it is now, and para 7 also, my lord, at page 14, your lordship will find para 7, page 13, petitioner states that petitioner company have successfully provided service in conducting several elections throughout India, and in none of the tender proceeding the above mentioned clauses have been incorporated. This shows malafide intention behind incorporating the clauses in order to favor specific bidder who is only qualifying these criteria. So, my lord, 1 person, 4 bids have come in, my lord, as of now, on the last date. Again, no, my lord, mention of, my lord, who, my lord, this particular, my lord, person is. Now, my lord, and yes. Now, my lord, what is important is, my lord, they, my lord, relied on, my lord, a Kerala tender, where, my lord, counting centers were, my lord, taken out. Now, my lord, kindly have a, and second point which was argued was that, my lord, here, my lord, the bid is being made, my lord, where there will be multiple, my lord, persons, my lord, who will be performing, my lord, who, my lord, could be given, my lord, the tender. And, my lord, on that basis, they say that, my lord, whose person who has, my lord, satisfies, my lord, the experience vis-a-vis counting center, my lord, can, my lord, easily do, my lord, what is, my lord, provided for in counting center as well. So, my lord, polling center and counting center. Somebody who can do so much work for a polling, my lord, center can easily do counting. Now, my lord, I want to, my lord, show your lordships, my lord, that, my lord, number 1, my lord, this tender does not say that it will always be, my lord, multiple, my lord, agency who will be involved. Kindly have a look at that clause. My lord, clause 22, page, my lord, 1. Oh, sorry. But he said still 130. My lord, moment your lordship gets tired of my voice, my lord, kindly let me know, my lord. No problem. Because it's also, my lord, lunch, but I know your lordships, my lord. My lord, kindly have a look at clause 24. Sorry, my lord, clause 24, page 111.
Selection of bidder.
Yes. Considering the scale of work, need for continuous monitoring and contingency preparedness during the general election to West Bengal Legislative Assembly 2026, the client reserves the right to award the work order to more than 1 bidder that matches L1 rate and meets the required technical criteria in the interest of timely. Selected bidder/bidder shall be issued a letter of it. Now, my lord, what is important is, it does not say that it will, my lord, give it to, my lord, more than 1 bidder. It was only reserving its right. Because, my lord, this is today, my lord, the purpose of the bid is to, my lord, deal with particular number of polling stations, particular number of, my lord, QRTs, particular number of, my lord, emergency response teams, particular number of NACAs, and particular number of counting centers. And, my lord, that, my lord, is, my lord, the scale, which is what is mentioned here. So, if we go for, my lord, 1 bidder, my lord, he should have also had, my lord, experience in counting centers. Now, the pre-bid query itself shows that they do not have, my lord, the counting center, my lord, experience at all. So, my lord, now, my lord, I want to show your lordship just 3 paragraphs of the tender.
So as per the clause 24, what is your submission? General, Clients reserve the right
It's
to.
just reserving. My lord, I'm not, my lord, saying from the beginning I'm going to give it to. I would prefer to give it to one. But my lord, if on the when the elections, my lord, are ultimately being held, my lord, exigencies require, my lord, a larger scale of, my lord, deployment. My lord, I will, my lord, provide, my lord, someone who matches the L1 rate, my lord, my lord, may engage them. It's reserving a right. Now, my lord, what's happened in Kerala and what happens in Bengal, my lord, your lordships would have realized, my lord, by now.
Yesterday I told you that it is a special state.
Yes, my lord, my lord, my lord, Bengalis are supposed to be, my lord, meek. My lord, that's our reputation, my lord, after independence. But, my lord, one place, my lord, where we match the best in the world, my lord, is, my lord, pre-poll and post-poll violence. So we have series of matters which says pre-poll violence and, my lord, another as post-poll violence.
Got a good experience at that.
I have, and my lord, so is your lordship, my lord, after coming here. Your lordship seen, my lord, so many matters, my lord, being moved. Now, my lord, it's not something to be proud of. So, my lord, if, my lord, we can actually, my lord, have, my lord, mechanism to deal with it. And, my lord, it's always better, my lord, if, my lord, one person, my lord, is, my lord, completely in charge. And I'll show your lordship, my lord, one thing. What is the purpose, my lord, of this tender? My lord, kindly take, my lord, page 70. My lord, clause 2.2. Which case?
Yes.
Now, my lord, kindly see this. 2.2. As per West Bengal, as per the Election Commission of India's instructions, all polling stations, that is 100% with internet connectivity, have to be monitored through webcasting to ensure oversight of critical activities. In West Bengal, currently there are 80681 polling booths. And the Office of the Chief Electoral Officer of West Bengal intends to monitor all polling booths with one camera inside and one camera outside each booth. However, kindly note this, 2 cameras may be installed inside critical booths requiring 360-degree view of the proceedings inside the booth. These 80681 polling stations are required to be monitored through webcasting. Moreover, the webcasting is to be carried out from approximately 108 counting halls, which would be conducted in large halls from designated counting counters. Besides, 1470 checkposts, 2646 FS vehicles, approximately 3093, that's quick response vehicles across the constituency as per instructions of the Election Commission. Now, my lord, kindly have a look at, my lord, the charts which have been given, scope of work. My lord, kindly come to, my lord, first is, my lord, polling stations and counting halls. My lord, counting centers are 108. Your lordship will find that at 71. 108 counting centers, which has, my lord, 421 counting halls. Because a counting center has several halls, my lord.
Yes.
So, my lord, 108 counting centers, 421 counting halls, polling stations, 80681. So, my lord, one is for polling, one is for counting. Now, kindly have a look at flying squad vehicles. My lord, per assembly constituency, at least 9. Total comes to, my lord, 2646, which is at page 72. Then, my lord, Naka SST checkpost. My lord, this is, my lord, 1470 at page 72. Then, my lord, 72 bottom, QRT team vehicles. My lord, 3093. My lord, the number of assemblies are 294. Vehicles, my lord, is, my lord, 3093. And, my lord, GPS tracking, my lord, of EVM, etc. My lord, this is 294, 50,600. Then, my lord, kindly see, my lord, one other, my lord. Which one? Yes. Now, my lord, the counting number, my lord, I just wanted to indicate to your lordship. My lord, this is at page 82. My lord, task 3, my lord. Kindly see recording of the counting process.
Yes.
Number 5, my lord, kindly see number of locations for audio video recording, 421 halls in 108 counting centers, 421 halls in 108. Then, my lord, kindly see the breakup. At counting center, 7 cameras per hall. At counting premises, 10 number of cameras per premises for other purposes. My lord, counting going on. My lord, everywhere else also has to be monitored. My lord, as to what is, my lord, happening. Is there, my lord, an interference? All this, my lord, goes up. This is the scale, my lord. It's for one person really, my lord, the tender. It's only if, my lord, exigencies, emergencies, and, my lord, if they need to, my lord, have a, my lord, backup, that, my lord, we are looking at, my lord, reserving our right to, my lord, engage someone else. So it's really one person. And, my lord, here they have admitted, my lord, that they do not have any experience regarding, my lord, counting. Now, my lord, third, and this is very important, my lord, we have, my lord, a situation, my lord, where, my lord, a tender term, my lord, is being challenged. Now, my lord, I'll just cite, my lord, one decision, my lord, before your lordships. My lord, there have been several. This is 2022 SCC online, SC 1334. চলো দিয়েছি তো তোমার এটা কোনটা ও দুটো দিয়েছে তুমি আচ্ছা দুজনে আছো নাও তুমি আছো জানি আছে বলে আমি বলেছি তোমাকে দিয়ে দিতে একটা my lord kindly take my lord paragraph 27. My lord, Mr. Kaur is usually quiet. My lord, his learned juniors are not. So, my lord, I ensured he also has a copy. My lord, kindly take, my lord, para 27. Even otherwise, even on merits also, the High Court has erred in quashing and setting aside the eligibility, I'm sorry, my lord, para 20, criteria 10, mentioned in the respective requests for proposals while exercising powers. Now, kindly see the settled position. As per the settled position of law, the terms and conditions of the invitation to tender are within the domain of the tenderer, tender-making authority, and are not open to judicial scrutiny, unless, kindly note this, they are arbitrary, discriminatory, or malafide. Now, if your lordship sees, my lord, the pre-bid query, my lord, they say, please rationalize a bit. Your lordship will find that, my lord, at 177.
Yes.
My lord, first paragraph. We respectfully submit that we possess the requisite experience of deploying more than 130,000 cameras for live web streaming at polling stations. In this context, we request the department to relax or rationalize the experience requirement pertaining to installation of CCTV cameras at counting centers. My lord, it's not, my lord, that it is, my lord. Then, my lord, what it says, the last paragraph, my lord, kindly see.
Therefore, we request the department.
Yes, to kindly allow bidders with at least one work order involving counting center deployment or bidders having experience of deploying a minimum of 400 CCTV cameras at counting centers to participate in the tender. Now, my lord, it's very important. My lord, this recognizes that even their case, my lord, that there should be experience regarding counting centers.
Yes.
And, my lord, in the petition, my lord, they've stated you should now have a separate tender for counting centers. I will give the paragraph. My lord, kindly see, my lord, paragraph 6. This is what, my lord, they have stated. My lord, at page, my lord, 11, paragraph 6 to
Paragraph 11, page 11.
Yes, my lord, at the bottom, last 3 lines. Lordship has, my lord, if the respondent authority genuinely considers counting center surveillance to be materially distinct or of heightened sensitivity, the legally appropriate course would be to issue a separate tender for such work. My lord, their query itself recognizes, my lord, that it's relevant, this experience, but says you don't scale it up to this much. And my lord, I'm showing your lordships that in counting center alone, 4,000 over 4,000, my lord, may be required.
Yes.
Now, my lord, I was on para 27. Kindly, my lord. As per settled position of law, the terms of the invitation to tender are not open to judicial scrutiny, the same being in the realm of contract. The government, tenderer, tender-making authority must have a free hand in setting the terms of the tender. Then, my lord, few cases are considered. My lord, I'm not citing them, but they're all quoted here. My lord, I'll, my lord, first start with Mabinda Express. Para 29, my lord, para 8 of Mabinda is being referred to. Kindly take the last, my lord, 6 lines of that page. This implies that terms subject to which tenders are invited are not open to the judicial scrutiny unless it is found that the same have been tailor-made to benefit any particular class of tenderers. So also, the authority inviting tenders can enter into negotiations. Okay, my lord, I'm not. Then, my lord, Michigan Rubber, para 30. Kindly come to, my lord, para 23 of Michigan Rubber, which is quoted, clause C.
In the matter of
Yes, in the matter of formulating conditions of a tender document and awarding a contract, greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of its statutory powers, interference by court is not warranted. Kindly see, my lord, the high bar. And then next D. Certain preconditions or qualifications for tenders have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. So, my lord, it's not just resources, it's the capacity.
Yes.
Now, here is some tenderer who comes and says, yes, this is relevant. I may not have experience here. So, you relax the relevance criteria, the capacity criteria. Now, my lord, in the aforesaid decision, it is further observed that the government and their undertakings must have a free hand in setting the terms of tender, and only if it is arbitrary, discriminatory, malafide, or actuated by bias, the courts would interfere. It's further observed, courts cannot interfere with terms of the tender prescribed by government because it feels some other terms would have been fair, wiser, or logical. Then, my lord, EduComp is also referred to. Then, my lord, the, my lord, case was decided, my lord, accordingly.
Correct.
My lord, my learned friends relied, my lord, on a case.
that is 19G.
Yes, and not just that, my lord, I want to show your lordship, my lord, one particular thing. Kindly have a look at the clause. My lord, para 13. Kindly have a look, my lord.
Yes.
We have considered the rival submissions and have perused the record. For the facility of reference, the impugned tender condition is extracted below. My lord, kindly see, past performance restrictions. Bidders must have supplied sports goods worth at least 6 crores. Now, my lord, kindly see, to state government agencies of Chhattisgarh.
Specific.
Yes, my lord, that was a restriction. There could be, my lord, at the end of the day, my lord, every government should see, my lord, that its citizens, my lord, get the best deal. So, my lord, if, my lord, if you confine it to Chhattisgarh, even though you happen to be a Chhattisgarh school, my lord, the best may not be coming at all. There's no, my lord, competition at all. Then, my lord, kindly see, my lord, paragraph 17. My lord, this is, my lord, the test. My lord, last, my lord, 6 lines. The eligibility criteria mentioned in the impugned notices must have rational nexus with the object sought to be achieved. That is, supply of good quality sports kits to students of the school at the best price. The eligibility criteria in impugned notices, therefore, should be framed in a manner which encourages wider participation and secures the best price for the state, which in turn safeguards the public exchequer. Then, my lord, paragraph 18, my lord, last 5 lines. The state, by linking the eligibility criteria with past supplies, has created an artificial barrier against the suppliers who had no past dealing with the state of Chhattisgarh. Impugned condition curtails the fundamental rights of bidders who have been ineligible to participate in the tenders.
Yes.
Now, my lord, para 19, last 3 lines. To confine the eligibility to participate in the tender within one state is not only irrational, but also disproportionate to the goal of ensuring.
Yes.
And my lord, para 20, my lord, level flowing, my lord, 19(1)(g). Now, my lord, here, did they do the 3-state argument also? তোমরা ওই 3-state argument করেছিলে? Yes. What are you saying now? Then, my lord, another argument, my lord, which was advanced was 4.4b. Kindly have a look, my lord, at 4.4b. My lord, kindly take the corrigendum, my lord, because it's the corrigendum which has to be considered. (285), my lord.
Yes.
My lord, they say, my lord, that you cannot say that 3 states criteria, my lord, can be at all a criteria, because one state may be large, one state may be small. My lord, my lord, eligibility criteria deals with, my lord, first, my lord, capacity and capability.
Correct.
My lord, capacity is already covered under 4.4a. My lord, capability, my lord, is the, kindly note, full work for a state. My lord, how you conduct yourself with a state election machinery. That is the issue. Now, my lord, the language was therefore changed. My lord, bidders came and said, don't say different states, say 3 different states. 3 states. My lord, that's the change which takes place. This was discussed at the pre-bid meeting. Kindly see, my lord, left-hand column, existing provision. Bidder should have executed at least 3 full state orders of live web streaming for web streaming of elections in different states of India on behalf of so-and-so during 3 years. This was changed. Kindly see, bidders should have executed at least 3 full state orders of live web streaming, so-and-so, for web streaming of elections in, instead of different states, 3 states of India.
At least 3 full state.
3, yes, and it's full.
Yes, full state.
My lord, of election. So, my lord, the experience here is to deal with, my lord, state elections. And, my lord, they are saying 3 states. Size of state is not important, because, my lord, size, my lord, of deployment is taken care of, my lord, in 4.4a.
Yes.
My lord, those are my submissions.
Thank you.
My lord, I prefer to go by my learned friend's words than my learned junior's words, my lord, because I'm not sure.
So I am becoming forgetful these days with my age.
No.
So we also rely on your junior.
No, my lord, we rely on each other, my lord, that's.
Thank you.
Please come to page 70. My learned friend contention is that, Lord, the petitioner had accepted that he did not have the capacity to meet this tender condition.
Yes.
Lord, please come to page 70. Lord, clause 3, scope of work.
Yes.
Now, Lord, your lordships will kindly come to the bottom of the page. Kindly see how many polling stations I have to handle. 421 counting halls.
Counting halls 421.
Has your lordship seen that? Kindly turn the page. Polling stations.
8,681. 80,681.
80,681.
Yes.
And then total counting centers
are 108.
108.
Now, if your lordship will not kindly come to page 75. Slot 7. I'm just not meeting my learned friend's point. Says supply and installation of IP-based, kindly see clause 7,
Yes.
HD CCTV camera in counting halls, minimum 7 cameras in each hall, and counting premises 10 cameras along with 1 manpower, so and so. So, my lord, 7 cameras in the hall and 10 cameras in the premises. So, your lordships may kindly come back to page 70. 70, the counting halls are for 421.
Yes.
So, my lord, the 7 cameras are required in counting halls
Correct.
and 10 cameras in counting premises. So, we are let us take the counting halls.
7 camera each hall.
In each hall.
Minimum 7 camera.
Minimum 7 cameras.
Correct.
421 counting halls.
Correct.
So 421 into 7. 420. Yeah. This is they say is the requirement. But our contention was that I am supplying you 1,30,000 cameras. I am capable of supplying you more than 1,30,000 cameras. But you are restricting it to counting halls. Now, I have shown in Kerala, this clause was there, they have done away with.
Correct.
They have done away. So, my lord, my contention was that if you have done away with on our representation, I have shown to your lordship that we had represented in Kerala, and on our request, they had done away with that clause. It's not the requirement of the cameras that we are objecting to. We are capable of supplying much more than 1,30,000 cameras. We are fulfilling this eligibility. But Lord, what they are trying to do is they are trying to restrict us by putting this 3,000 supply in the counting halls. That is what was objected to. We have never said that we are not competent to put these cameras in the counting hall. We had said that do away with this criteria, and that is what has been done in Kerala. Now, Lord, this is the first point. Lord, my learned friend perhaps Lord said that Lord, this is a requirement of the tendering authority. If this is a requirement of the tendering authority, they can't have different stand in different states. In Kerala, Lord, this was there, included in the tender. But Lord, post our representation and considering that it is a superfluous Lord barrier which is being created, Lord, they had removed it.
Yes.
So this is not on the question of the cameras. Now, Lord, the other point is, if your lordships will not kindly come to my page 159 on my capacity. Please come to page 159. 159.
Yes.
Lord, we were successful in Lord providing this facility in Uttar Pradesh. Now, Lord, page 159. Kindly see, Lord, how many booths we had handled. Kindly see the certificate, which is at page 159. It says this is to certify so and so, so and so. Webcasting of poll proceedings on the day of poll in the Lok Sabha general election 2024 in the state of Uttar Pradesh. The work of webcasting was satisfactorily completed in 81,036 polling stations in 75 districts and 80 parliamentary constituencies. Now let's see how many polling booths are there in West Bengal. Polling booth. 81, page 71. Page 71, your lordship has taken note of that.
Yes.
It is lesser than Lord what we handled in Uttar Pradesh. And Lord, the object is, Lord, if I can supply cameras in Uttar Pradesh and in Kerala, Lord, why should I be disqualified in West Bengal? The same authority is holding the election.
Yes.
And Lord, that 3-state barrier, Lord, it is absolutely not an artificial barrier which is created for the purpose of limiting lot 3 to 4 contenders, as I have stated in paragraph 28 of my petition. I had placed it on the last occasion. Your lordship will see my pleading in para 20. And I had said that there will be not more than 3 candidates. And my learned friend Lord today has confirmed that there are 4 offers that they have received. But the object of a tender is, Lord, if my learned friend is relying upon this clause, which he has relied upon at page, no, that clause 24, page 111. If your lordship will not kindly see, and he says that this is a reservation of right that he has maintained for the purpose of splitting it if there is an exigency. Look, the more the merrier. There should be more people participating. If he is considering an exigency to this effect, then there should be more people who are participating, who should be participating. And Lord, I had cited this judgment. Lord, I am not disputing the principles of law on which my learned friends rely. That's a normal, Lord, situation where, Lord, this law will apply.
Yes.
But Lord, I am relying on this on 3 aspects. First is, Lord, they are not keeping the same level playing field in every state. There has to be some reasoning for that. There is no reasoning. Lord, coal violence is there in Kerala, coal violence is there in UP. There is no specialty so far as coal violence is concerned in West Bengal. So, Lord, same parameters should apply, number 1. Number 2, Lord, equal opportunity to participate is being denied. And that was what the main contention in this petition was. It was not because, Lord, they restricted it into the state of UP.
The only question is that how you can say to restrict now counting should not be given and is to be given.
No, I am not saying that. I'm saying that should not be a ground of eligibility. If you increase the number of cameras to 1,34,000 to 5 lakhs, I don't mind. But question is, Lord, you are saying that putting the camera in the counting room, that is a criteria. That criteria was put in Kerala and was removed. Lord, if you can remove that criteria in Kerala, considering that it's not a viable eligibility criteria, then Lord, why not in West Bengal?
Okay.
There should be a special equity shown that this is for West Bengal, this has to be maintained.
Yes.
I am saying that if you have, Lord, if the Kerala, they had stuck to it, if in Uttar Pradesh, they would have stuck to it, I would have said that yes, this is their policy, they are sticking to it. There is no, Lord, spelled out reason as to why, Lord, this clause should be there.
Okay.
Lord, these are my.
2 p.m. is the opening.
Beg your lordship's pardon.
Yes.
2 p.m. is the opening.
Yes.
That can be postponed, Lord.
Can it be taken tomorrow, the opening?
Just find out.
But in fact, I am not saying that you cancel the tender or anything. I say that you allow me to participate before opening the price. Sorry to have detained your lord.
Yes, my lord, we are very sorry, my lord. I'm just checking, my lord.
That one interview.
No,
I had opted leave yesterday, my lord.
Tomorrow, it can be fixed at tomorrow 2 p.m. Then I
Yes, my lord, I'm just, my lord, I'll inform them.
Yes, what is the
My lord, yesterday I had obtained leave, my lord, your lordship permitted me because of difficulty. One matter, my lord, some urgency. But it's not that it has to be taken up tomorrow, but next week, my lord, or the week after that, whenever your lordship, my lord,
It's not in the list.
No, not really.
Give the list. Give the urgency to make it.
No?
Open
Upon notice. In fact, Mr. Mukherjee is my leader.
Which one?
In the matter.
Huh? Oh, best.
That's why I'm telling to my colleagues I have been experienced in the commercial, then I brought to the tender talk.
But my lord, this is called domain expertise, my lord. But there's probably more variety, my lord. Yes, this side. My lord, I'll speak, my lord. I'll speak. They can't get through.
Yes,
I'll
please
speak.
repeat it tomorrow, and I will deliver the judgment tomorrow morning itself.
Yes, I'll just. My lord, let it be understood. My lord, if I cannot communicate, it happens. My lord, I'll see to it that it's not, my lord.
Yes, that
I'll take that.
taken. Let me come back. 90.
আমাদের সেভেন তো আমাদের
Yes, 19 March. Correct. Why you all persons, whenever time permit, come and mention. Today 3:30. Which matter? So tomorrow is the only one working day. So all other matters are there.
19.
Till serial number 10, I think all urgent matters are there. Urgent to urgent, then another one is. कोई देख लो 10-11 में. He's coming here or through virtual world?
He's very
That
fond
mark
of the
for it.
biryani that they serve in Calcutta.
It will be in the urgent motion within 10 or 11 matters. Let us see. Sorry.
At number 19.
Already ordered.
19 March. I beg to appear on behalf of the state.
My mistake. For final getting come up. But I am absolutely ready. Number one.
So you want adjournment?
My lord,
And today I delivered. You have taken the books. You take the. There are two one. Yeah, I think CLJ and you take that.
my lord, I am suffering the interim order. The interim order is against the policy decision of the government related to transfer of the land from one department to another department. Inter-department transfer. That is the policy decision of the government. Whether my lord the court can interfere or not.
It's a railway.
No, my lord. This is Gram Panchayat claiming that it's property, but it is being used by the police authority, and the practically, my lord, the deed petition is
Okay.
maintainable.
So you are having some difficulty with regard to the injunction.
My lord,
You are facing difficulty with regard to the stay order.
stay order.
So what is your submission?
My lord, my submission is, my lord, let it be heard. What is the case of my learned friend? I will give the reply. Deed petition is not.
But today is having some difficulty.
Let it be then Monday, interim order till Monday.
But I cannot fix the date on Monday because my diary is totally filled up till April. What can be done? If I will fix an urgent motion, then you can come and argue that I can do that. I will fix in the urgent motion matters, so you will get the time, then you can argue. Though the matter is specially fixed today at 2 p.m. for hearing, but the learned counsel for the petitioner is having some personal difficulties and prays for adjournment. He further submits that the interim order is still today and prayed for extension of interim order. Learned counsel appearing for the state raised objection and submit that the petitioner is enjoying the interim order for which the respondent authorities are facing difficulties, and he prays for hearing of the present application as early as possible. At the learned counsel for the respective parties, though the matter is specifically fixed today for hearing, but learned counsel for the petitioner having some personal difficulties, according case is adjourned. Let the matter appear on 18th of March 2026 under the heading urgent motion within 10 matters.
My lord, at 2 p.m. my lord.
Within 10 matters.
Well,
Within 10 matters.
before 2 p.m.
2 p.m. then I will go to the April. That's what I'm telling you. 2 p.m. April then. You ready? I will fix in the month of April, last April.
My lord?
I will fix in the month of April at 2 p.m. 2 dates I will give.
No, no, my lord. My lord, I am suffering the interim order. This is one of the policy decision of the state.
Interim order is extended till 20th March 2026 or until further order, whichever is earlier. ठीक है 19 करी then 19 करी then interim order till 23rd of March or until further order. Yes.
Otherwise, ready, my lord.
Okay.
But that is suffering.
That's why I fixed the urgent motion within 11 matters.
My lord.
Yes, next.
Opponent, I cannot oppose much also.
My lord, I am appearing for the respondent back.
How you are in appellate side?
Omnipresent.
Willful defaulter.
ইন্টারিম অর্ডার উমরিতে একটা কোন রকম পাস করে দিয়েছে উমরিতে বাড়ি ইন্টারিম অর্ডার এক্সটেনশন দিয়ে চলে যাচ্ছে সব
In this matter, my lord, I have taken 31 crores of rupees from the bank. Thereafter, my lord, I have given settlement letter. Settlement letter for 30 crores of rupees. 33 crores of rupees. Along with the settlement letter, I have given a 1.65 crores deposit to the bank. My lord, they have encashed them. After encashing the money, my lord, they all of us are in on April 2024, my lord. They had issued a notice under by the identification committee. The same notice was issued by the assistant general manager. We had challenged that pursuant to the review for the notice, the assistant general manager does not have any right to we have challenged the majority the same notice non-institutional. And subsequently, we have decided to that notice. Then again, after deciding to that notice, the bank did not the bank had issued notice with regard to the identification committee that I have reached. But subsequently, we have came for the Honorable High Court that I covered by two judgments of the Court and the Honorable Court. I have shown the order, the Honorable Court order. Might have become and wait the super notice by
What is can 1? Can 1, can 2?
But after when the matter was published, they had issued a notice for appearing before the Supreme Court. Thereafter, I had filed one lawsuit and given notice to them. Immediately, when I have given notice to them, they have withdrawn that notice. So that become instructor. Then again, they have issued the notice that tomorrow they are in spite of the fact the matter is submitted, tomorrow they are going calling my client for the review committee. I under submission to the lawsuit, the said matter is submitted. The said matter is before this honorable court and for final hearing before your lordship, my lord. My lord, until and unless as of today, my lord, this notice is issued by the assistant general manager and pursuant to clause 3 of the willful defaulter, the minimum criteria for things are provided in executive register or equivalent with regard to the same. So this notice is valid in law. So if this identification committee notice is valid in law, therefore the subsequent review committee cannot proceed until disposal of this. My lord, will kindly come to.
If the decision is taken by the competent authority and the notice is issued by the officer concerned, what would be the effect of that?
My lord, my main issue is this, the person cannot be delegated, the power cannot be delegated.
Not power.
He cannot delegate, my lord, will come to state the notice. Can 2 is 30.
Resubmit your OTS.
My lord, you see.
Can too.
Can is, can has become
instructor because they are. Can.
What is the can two?
Can.
What?
Can to
What is the can two?
Can two is the second notice issued by them challenging that.
Page 37.
37 is the notice dated 24 April 2020.
What is the status of the writ petition? Affidavits filed. Affidavit filed.
Fine, my lord.
Reply filed.
Fine.
Ah.
Final hearing, your lordship, fix the date and here's the petition, my lord. Finally.
Yes.
my lord, my lord.
I mean, my lord.
Yeah. From the very beginning, their grievances were about the transparency of the notices. And in our report, come affidavit in opposition, we have in very details, we have shown about the 2015 circular of
That is correct. Now you have issued the notice of the personal hearing.
my lord.
Correct.
I am coming to that point. From the very beginning, there were twofold of grievances. One is transparency. Second is for not giving any personal hearing. So when this matter was being heard before Justice Sinha, we have also in the writing also we have given, we have no problem in giving personal hearing. So it may be done. We have now given them personal hearing. Now they are trying to evade that also. My lord, it is a matter of few crores, 357 crores on the books as on today. So my lord, we have tried to follow every rule as per the RBI circular. After that also, then when they have not given the appropriate reply, which was not satisfactory, we have again given them the personal hearing. Now they are trying to evade that, my lord. And whatever in the affidavit we have said, we have dealt every points about the transparency, about the ED committee, which they have alleged there was no ED committee. It is there, my lord. We have annexed all the documents that all the process has been duly followed. Now the hearing is tomorrow, my lord. And what they are saying that we have withdrawn that after receiving, my lord, that is wrong data, because we have withdrawn on 12th. They have given us notice on 13th, which they have affirmed on 12th. So until 13th, we have no knowledge that they are filing this can. So we have already withdrawn and given them a fresh date. So my lord, every transparency has been maintained, every rules have been followed to give them opportunity, and nothing has been decided. It is only a process of identification, and the review committee is still in the process of giving order, my lord. In spite of they not attending, they're not giving any proper reply.
What order you are challenging the writ application?
Page 148, your lordship will come to page
148 of?
Of the can two the order.
Yes.
Steps taken by Punjab and Sindh Bank to declare the petitioner that eligible defaulter is included in the income. The executive submission is that the so-called notice dated April 24, 2024 and July 12, 2024 were issued by the Assistant General Manager of Punjab and Sindh Bank, who is not the competent authority to notice in terms of master circular issued by Reserve Bank of India. Learned senior advocate the petitioner refers to two judgments, one of the Honorable Supreme Court in the matter of State Bank of India versus Yah Developers Private Limited reported in 2019 787, and so your lordship the judgments and others by the coordinate bench of this court is the case of Atlantic Projects Limited and others, Allahabad Bank reported in 2019 488 on the issue that requirement of issuance of so-called notice cannot be delegated. Here it has been issued by the Assistant General Manager, it cannot be delegated. The requirement must be filtered by the identification committee. My lord, learned counsel for the Punjab and Sindh Bank seeks time to obtain instruction in this regard. Let a report by way of evidence and supporting documents disclosing as to whether decision was taken at all taken by the identified committee to initiate proceedings against the petitioner for declaration as willful prepared and circulated by April 17, 2025. Released the petition on May 6, 2025. My lord, thereafter, pursuant to this, my lord, we come to 150. What happened? It's ordered, my lord. Last time they hadn't filed the report. Next, takes of order.
No, that's correct. That's correct. See, two options. Writ petition is to be heard because exception is filed. Now it is to be heard on merit. Now they have issued the notice. One is ground with regard to the opportunity of hearing. Second is ground with regard to the incompetent officer has issued the notice, which is not sustainable. These are the two grounds.
That only review committee has issued this notice. That can't be issued as of today by the review committee. Because the identification committee notice is itself under challenge. So, my lord, will come to annexure A, what notice they have issued, what I have challenged. Page, my lord, page 20, the review committee, my lord, if it was a regard to identification committee, I would not come before this court. Because review committee is the second stage. Review committee is the second stage. I'll show you a lot of the circular, my lord. This is with reference to the caption subject in this correction. We may inform you that the committee for review of withdrawal defaulter has decided to grant physical personal hearing to Mr. Ramprasad. This is the review committee. This is the second stage. Now, my dear lordship comes to page 40, the notice. Who can issue such notice that to withdrawal default? This is the Reserve Bank of India guidelines with regard to the willful defaulter, your lordship. Your lordship will come to how the executive committee will work, my lord. My lord, 3A and 3A, the mechanism referred to in para 2.5 above should generally include the following. The evidence of the willful default on the part of the borrowing company and its promoter, whole-time director at the relevant time should be examined by a committee headed by an executive director or equivalent and consisting of two senior officers of the rank of GM or GM. And your lordship comes once to page 37, my lord, who has issued this notice.
My lord, the first para is...
This notice has been issued by page 39, your lordship has issued by the Assistant General Manager, Sambar. If the committee concludes that an event of willful default has occurred, it shall issue a show cause notice to the concerned borrower and the promoter, whole-time director, and call for their submission. And after considering their submission, issue an order recording the fact of willful default and the details for it. And opportunity should be given to the borrower and promoter, whole-time. So I am telling this notice is itself is knowledge in the eyes of law. And thirdly, my lord, see, and that has been challenged.
Where from you are reading?
My lord, page
2015 circular, circular 2015.
Willful default circular 2015.
Page 9.
Page running.
So you are not interested to go with the personal hearing?
No, my lord, I am not interested. My lord,
Okay, I will do one thing. I will record you are not interested to go for the personal hearing, that the hearing be postponed. I am fixing a hearing on the total matter for hearing. Let it be.
My lord.
My lord, as your lordship wishes, but before that, before you go for such order, my lord, this submission, whatever it was, I felt it was misleading, my lord. The mechanism for identification of willful defaulter, my lord, if you like to take the 2015 circular, my lord, it is in the record we have submitted. The paragraph A says this is the evidence of willful default on part of the borrowing company and its promoter, etc. at the relevant time should be examined. The whole default procedure, everything has to be examined by a committee headed by executive director. My lord will be pleased to come to my report and annexure R1, my lord. Only I am showing you how it has been submitted and what is in fact has happened, my lord. My affidavit in opposition cum report, page 22 is annexure R1.
Yes.
The first letter 16/124 is for examination of willful default and it is a note for ED committee, my lord. As required in law and in the circular, it says one executive director and two general manager post, two officers of post of general manager. Now this note is given by Samvar, the branch which was dealing with the account, note for ED committee, and the whole details why it has been identified that they have done something to fall within willful default. And R2, my lord, I'm not going, since it is not being heard in for the rate, I'm not going. I'm showing that this is a note for ED committee by the branch. Obviously, they have to give the details of the account. My lord will come to R3, my lord. That is and it is in page 30, my lord.
Page?
30. Skipping R2, I'm coming to R3.
Yes. Identification committee.
Yes, my lord. My lord can see the members. One executive director, chairman of the committee, two general managers. As per law, as cited by my lord, whatever has happened is there in front of your lordship in record. Whatever, this is the internal, all documents has been disclosed, my lord. And my lord, this committee along with this account has also examined other accounts, and now agenda 2 is this account, and it has gone into details why the actions of this company has been identified as willful default. And then this committee, after examining, being satisfied, has given permission. Now lordship will come to R2, my lord. Page 27.
Yes.
This is the permission from that committee itself to issue a show cause notice. My lord, they have not delegated their power. It is only the machinery under them which they have used. Have I commented while you were submitting? Very bad practice.
Yes.
My lord. So these are the main 3 documents internal which shows the transparency and what they have followed as per the RBI rules 2015, and thereafter RBI circular 2024 has also come. We will concentrate on it afterwards. But main allegation, and my lord, I can show you one paragraph from their writ petition where they are saying that personal hearing. Yes. Page 43, para 43, page 12 of their writ petition, my lord, they are saying that we have not given them any personal hearing. It was their allegation and grudge. Page 43.
Page 43 of writ.
Writ petition, part volume 1, page 43. Sorry, page 12, para 43. Since I'm not going into hearing of the writ, my lord, I'm just indicating whatever they have submitted today. 43. No opportunity of personal hearing was given to your petitioners.
No, now you are already declared the default, willful default.
No, my lord, each notice, if you go through, it was only a process of declaring, process.
Where is the notice, imping notice?
My lord.
Very well, my lord. She says process of declaring that to be set aside.
Set aside, question of set aside does not arise because it was not declaration, my lord. Wait. Wait. Purpose of the note, it was.
Kindly come to the page 43. Kindly come to the page 43 of the writ petition. This is the notice you are challenged. Page 43 is the under challenge, na? So cause notice. 41, that's why 41.
For not classifying. Yes. It has not yet been classified.
Now come to 43. Last paragraph.
Please note that in case of submission of objection, we take the bank to declare
my lord, the reply was very vague, my lord.
So thereafter any order is passed?
No.
Not.
Thereafter they again passed an order that we have specifically taken an order.
No, after the so-called notice you have submitted the reply.
We have submitted that we do not have any.
You submitted the reply, whatever it may be. X, Y, Z, whatever whether the final order is passed or not. Where is the order? Where is the order?
In spite of that, that's why thereafter we changed the order. Can to also.
Not can to in the writ petition where?
P15.
Huh? Where is in the writ petition? Where you enclose the order?
35.
Huh?
Page 135.
135. 135 can't be. Ah. 143. Declaration of whole-time directors, willful defaulter. So this is the last order. This is the order.
This also we have checked.
So this is your challenge.
Imperative, my
24
lord.
April and this is
My lord.
24 April show cause notice without jurisdiction according beyond the willful defaulter circular, my lord, you cannot take it, and thereafter, in spite of our reply, they issued this final default. These two have challenged and came before the honorable.
My lord, the last paragraph of 12 July. However, based on the available evidence and lack of satisfactory explanation for the identified discrepancies, it is unequivocal to willful default has
occurred commencing
credit facilities sanctioned by your bank. It is imperative to report. We have not yet reported, my lord. We have stated, my lord, it is imperative to report as per RBI guidelines, but we have not yet reported. We did not say it is, we are reporting. Hence, it is not the order, my lord. The order has to be taken by review committee, my lord.
So why this letter has been issued?
My lord, this was issued saying because they have given a reply. In reply, we have stated your reply was very vague.
Correct. So
very
what?
vague, and so if you do not give a proper reply, it will be imperative on our part to go as per rule. But this was not the order, my lord.
Not as per rule, they have declared clear.
My lord, this
Where
the
is
line does not say that, my lord.
where is the declaration?
My lord, see, my lord, at the top.
Yeah.
At the top, page 146, declaration of whole.
That is regarding. Where is the final finding? That is regarding that you are writing a letter to the administration regarding reference subject.
My lord, the identification county mathematical review the report.
Kindly come to the page 147. Kindly come to page 147, last paragraph. Last paragraph. Read it. In accordance with the guidelines, so and so, where is the willful default declared?
My lord, that we itself we are telling, my lord.
This court find that the bank has issued a so-called notice on 24/4/2024, calling upon the petitioner to file their objection as to why the petitioner shall not be declared as willful defaulter. On receipt of the said so-called notice, the petitioner has submitted a reply to the bank. On receipt of the reply, the bank by a letter dated 12th of July 2025 informed the petitioner that the representation submitted by the petitioner is not satisfactory. It's not satisfactory. But the bank has not taken any, bank has not passed any order by declaring the petitioner as willful defaulter. Now the bank has issued the notice to the petitioner for personal hearing on 12/2/2026, directing the petitioner to appear before the committee,
Review committee, my lord.
to the review committee appear before the review committee on 27th of February 2026. Full stop. This court finds that the bank has not taken any final decision, and still the bank is giving an opportunity of hearing to the petitioner, and the notice has been issued to the personal hearing. Thus, this court is of the view the petitioner is having any grievances either with regard to the authority of issuance of the so-called notice, notice dated 12th of July 2023, and the committee who is holding for personal hearing, the petitioner can raise all the points before the review committee, and the committee entitled to take appropriate decision on the submission of the petitioner according the writ petition is disposed. Next. Next call.
21, my lord, I'm appealing for the petition. My lord, I would be, my lord, beseeching, my lord, on the last occasion, I'm grateful to your lordship, my lord, that your lordship directed the Child Welfare Committee as well as the state, my lord, to submit their reports. My lord, can recall this is the case, my lord, where the mother is seeking, my lord, custody of her child. My lord, I would first, my lord, ask, my lord, beseech your lordship, my lord, to impose exemplary cost, my lord, upon the Child Welfare Committee as well as the state, my lord, for giving misleading reports. But why do I say that?
My lord, there is a direction to file in opposition exceptions.
My lord, I will now, my lord, want for exemplary. Why? Because this report, my lord, is a case of complete suppression. I will show it to your lordship. My lord, we kindly takes up, my lord, first and foremost, annex to
Well,
P1.
first my learned friend undertake before.
Let me make my
No,
submission
no.
clear.
First my
Let
learned
me make my submission clear. One
First my learned friend.
Let me make my submission. First and foremost, my lord.
I will hear you.
But I am not question of hearing. My lord, let my learned friend accept that they will not pressing for any exceptions.
I am filing my
But without giving us any copy.
My lord, today, my lord, I am today before your lordship, my lord. Your lordship.
I have a right to go through.
My lord, very well. I will not.
You are filing exception
My lord,
or not?
I have the exceptions ready. If they take an attendance, my lord, for the time.
But it is not been served.
My lord, over here.
Please
You
serve
don't,
me.
my lord, over here, your lordship kindly see, my lord, from the facts of it. The mother has asked, my lord, for the child. My lord, initially what had happened, we had approached this writ court. My lord, the writ court initially asked the CWC to find out the DNA test and give the child back to the mother based upon the DNA. Subsequently, my lord, an FIR comes about to be registered at Maniktala police station, where it was alleged it was the mother who had kept the child in a dire circumstance and there was some abuse upon the child, on the basis of which, my lord, before Justice Sarkar, an order came about to be passed that very well, as pursuant to the outcome of the investigation, the mother will again apply for the custody of the child. My lord, outcome of the investigation happens. Outcome of the investigation, my lord, ensures that the mother had no responsibility whatsoever. FRT comes about to be submitted, my lord, against the mother. Thereafter that, we inform the Child Welfare Committee that you please return back the child because there's an FRT, there is no case against him. Now, my lord, we kindly see the reports which have been filed by the state as well as the Child Welfare Committee. This report of the TWC, my lord, does not mention anything with regard to this FRT being submitted, and it goes on to proceed as if I have committed the domestic violence or domestic abuse upon my child. My lord, we kindly see, my lord, one by one, my lord, the orders. And today, my lord, they are saying that the child has been kept given for adoption. But whereas I am the mother who has been going from pillar to post asking for the custody of my child. Madam, I kindly see, Madam, first and foremost, Madam, the first order which was passed by this honorable court. Madam, annex to P3.
Annexa?
P3, Madam. Page number 30.
Of your writ petition?
My
Yes.
Madam, I kindly see, my lord, the order which was passed by this honorable court.
Page?
But I'm just 77. 30. Madam, I first take the page number 73. Madam, I seen 73, Madam.
Yes.
The writ petitioner claims to be the mother of a newborn male child in her house. The mother and the child suffered an accident. Baby was taken to the hospital by the police, accompanied by the father. Thereafter, handed over to the Child Welfare Committee. Petitioner prays for returning of this child to her. Learned advocate representing the state respondent submits upon instruction that the police have not yet confirmed either the maternity or the paternity of the newborn baby. Police has handed over the baby to the Child Welfare Committee, where the child is presently stationed. Upon hearing the parties, the court is of the opinion that the Child Welfare Committee should take steps to ascertain whether the petitioner is the mother and Ritam Das is the father of the child in question. Madam, marks it. It has been now confirmed. You are the parents. This has now been confirmed. It is nobody's case. It is not. The petitioner and her husband are directed to cooperate with the process to ascertain the maternity and paternity of the newborn baby. If there is no dispute with regard to the parentage of the minor child, then the Child Welfare Committee, in the presence of the police, shall hand over the minor child to the petitioner. Steps shall be taken in the matter at the earliest, but positively within a fortnight from the date of communication of this order. Matter is directed to appeal. Now, my lord, after this, my lord, what happens? My lord, an FIR comes about to be registered at Maniktala Police Station, which is at page number 75. My lord, over there, your lordship will kindly see. My lord, it was lodged by the chairperson of the Child Welfare Committee.
Yes.
My lord, the allegations are of 308 of the Indian Penal Code, my lord, that is attempt to commit culpable homicide. My lord, based on the fact that the baby was found from a dire circumstance. But this report came about to be placed, my lord, in that writ application at page number 77.
Yes.
It appears that the interim order passed by the learned coordinate bench has been complied to the extent that the DNA samples have been obtained. With regard to the prayer for handing of the child, this court is not in a position to pass such direction. The child cannot be returned to the mother at this stage in the facts and circumstances which have come to light. That was the FIR at that point of time. Because at that point of time, the FIR had been registered immediately. FIR was in the month of June, this was in the month of July. Learned Senior County Counsel so submits that the newborn baby was found in the drain with serious injury. The child had been cut at various places. The police found the child and took the child to the hospital. Thereafter, the child was handed over to the Child Welfare Committee. The police authorities, upon making preliminary inquiry, have registered an FIR, and the mother is an accused. It is denied that the father had taken the child to the hospital. The complicity of the mother in the offence alleged, the mental stability of the mother, and whether any other person was involved in an act of causing bodily harm and injury to the baby are required to be ascertained first. Investigation by the police will reveal the truth. The child is safe with the Child Welfare Committee and is informed that the child is recovering. Under such circumstances, writ court should not interfere. It is further stated that the mother's hospital discharge paper have been tampered with and the police authorities are not sure if they're all genuine. The law provides the mechanism as to how the parents can approach the Child Welfare Committee for the return of the child, and the parents will be at liberty, petitioner will be at liberty to do so, strictly in accordance with law and the appropriate stage after the DNA results are available. Accordingly, my lord, it was informed that the CS has been approached. CWC will decide the prayer to return the child in accordance with law at the appropriate stage. Now, the next page, DNA test of the and return of the child upon the child's parentage being confirmed were directed at the interview have not been brought to light before this court because of the additional circumstances which were there at that point of time.
Yes.
Now, my lord, your lordship will find then we preferred a writ application challenging the FIR which was lodged against. During the pendency of the writ application, my lord will kindly take up page number 81.
Yes.
FRT comes about to be submitted, my lord, insofar as the present petitioner is concerned with the mother. And the accused was ascribed as the mother of the present petitioner, who has expired on the 4th of November 2024. That is the police's word. Now, your lordship, after investigation by the police, your lordship kindly takes up page number 84. I'm not troubling your lordship with the other part. They were collected, all these statements, everything was collected. They came about to be, the FRT came about to be submitted, stating that I had nothing to do with the incident at all by the police authorities, page number 84, second paragraph. In course of investigation, it could be ascertained that there was a love affair between Ashwita Potham and the petitioner and Ritam Das, that is the father. And they are married now. They are got married hiddenly without the knowledge of their respective families. As such, they continue to reside at their respective previous homes. From their wedlock, Ashmita Putta became pregnant on so-and-so date, gave birth to the said male baby at a residence at the first floor case, and so-and-so. Her mother, namely Lakshmi Putta, she has expired on the 4th of November 24, as per the police version itself, was the head of the family and had totally control of the family. She did not accept such type of relationship and raised a strong objection over this. Being frightened of their social reputation, she dropped the newborn baby in a narrow lane in an uneven ground adjacent to her building between two walls in the absence of Payal Poddar. Payal Poddar is the mother, petitioner before your lordship. In the evening on 23rd of March 2024, as a result, baby received multiple cuts and bruises. Meanwhile, on hearing the sound, so-and-so was rescued, and in the meantime, Ritam Das also arrived at the spot and taken the rescued baby to the police station for seeking assistance for medical treatment. So, my lord, my version that the father had gone with the police for seeking medical assistance has been confirmed. Secondly, the mother has been discharged from the case. She was not there. And thirdly, the mother has been running from pillar to post to ask for a baby. Thereafter that, my lord, page number 85, since, my lord, FRT comes about to be submitted, page number 85, my lord, coordinate bench's direction, my lord, if FRT comes about to be submitted, the third paragraph. Having considered that the final report has been submitted, I direct that the further consequential release, the petitioner will approach the appropriate forum. If the DNA report is required, the petitioner would approach the learned magistrate before whom the final report has been submitted. We have now been confirmed as the parents. Now, my lord, over here, we have then asked, my lord, the Child Welfare Committee that now that FRT has been submitted, page number 87. And that I have no role to play in this crime, and that the DNA report is in my favor, and I had nothing to do with this, and my version, what was stated initially, because initially, my lord, it was projected as though the mother was the person who had done this crime. But now that is not there anymore. My lord, in spite of that, they did not respond. We had approached your lordship. Now, before your lordship, my lord, CWC's report, which was filed. In my copy, my lord, it is undated. I don't know what is the date of the report, my lord. It is an undated copy. My lord, compliance report in connection with, my lord, that report of the CWC. My lord, they had given the background. Now, my lord, this is being filed before your lordship after this entire period of events have happened, which are all on record. What do they say, my lord? First and foremost, my lord, medical documents establish that the child was a victim of extreme abuse and abandonment. That is the first. Petitioner came to the father, did not accompany the rescue. So, my lord, the first point, proceedings before the Child Welfare Committee. First point, medical photographs and rescue video has been placed before the Honorable Court, establishing the child was a victim of extreme abuse and abandonment, not according to the police version. So, a petitioner person later claimed to be the father did not accompany. Hospital records bearing his name was found to have been tampered as already observed in the earlier proceedings. It's nothing but a reiteration of the earlier order when investigation was not over. The alleged mother could not offer any credible explanation as to how the newborn baby was found in a drain in such a condition. Again, my lord, prior to investigation story, given the severity, FIR was lodged. No mention about the FRT being submitted. Adoption procedures were complied with, though a lady alleged mother approached the Child Welfare Committee but could not produce any substantive claim in support of her claim. But these are the reports which is being filed before this honorable court. As the child remained unclaimed and as per the procedure continue, how are they saying unclaimed when I have approached them? Then after that, they issue a public notice. Child was declared as free for adoption. Child is not under the custody of the Child Welfare Committee, has been placed on pre-adoption foster care strictly in compliance with law. Thereafter that, your lordship will show that again the earlier order was reiterated. And point number 2, newborn baby was abandoned in extreme pain. Nature of injuries indicated deliberate abuse. Material discrepancies exist in statements of alleged parents. Malad, today, how can the Child Welfare Committee, Malad, come up with this report before your lordship? I'm asking this question, Malad, to myself.
Yes, that's a.
Yes, Malad. This, Malad, as far as the state's report goes, Malad, so Malad, in essence, Malad, this report which has been filed on the face of it, Malad, is absolute suppression, misleading, and Malad has been given, Malad, without even a care or thought, Malad, before that this honorable court how a report should be filed. Malad, with regard to the state's report, Malad, they have at least admitted that there was a FRT submitted, though, Malad, the state's own report is again contrary in a way to the police's final report.
Yes.
And that final report is accepted. These are my submissions.
Yes.
My lord, kindly come to page 7. I am for the respondent number 2, Child Welfare Committee. My lord, kindly come to page 77. My learned friend has already placed on record.
Yes.
Page 77. My lord, I only placed, my lord, page 78.
Yes.
Only 3 paragraphs. My lord, I am emphasized on para number 7, but I would like to indicate para 5. The law provides for the mechanism to how the parents can be approached to the Child Welfare Committee for return of the child, and the petitioner will be liberty to do so strictly in accordance with law at the appropriate stage after DNA result are available. This CWC has already been approached, and the CWC will decide the prayer of return of the child in accordance with law at the appropriate stage. No?
Will take the original side after this. And today is 3:30. I don't think. No approach.
No application.
Now, my lord, I shall emphasize on para 7 of the judgment. The DNA test and the return of the child upon the child's percentage being confirmed will directed by the interim stage. And when these facts are brought into the light before the court, it were not available. My lord, kindly mark then. Proof of maternity alone in this case would not be entitled the mother to take back the child.
Then now I sure that you will take this point. Now come to the state report, paragraph 3. Come to the paragraph 3 of the state report.
My lord, I have not.
Go.
Paragraph 3.
Second page, paragraph 3.
Second page. My lord, regarding DNS,
read.
There are a rumor in the locality that subject that baby was willingly kept in abandoned in his mother.
Last 3 line. Accordingly, 19 June 2024, DNA samples were sent for expert opinion, white case file number so and so. Report of newborn male baby matched with Asima Poddar. Okay, leave. I am accept your submission. Now come. And Ratan Das. Now kindly come to the page 79. Only maternity, not paternity, court has held. If both have been come to the conclusion, expert report, maternity and paternity. So what further remains?
My lord, regarding our case,
who is the chairperson? He has to come here. How he has given the child in adoption?
My lord, kindly see. My lord,
I want to see the chairperson. Under which authority has given the child even after the FRT, and how we file this report without taking the recourse of taking the report from the police authority with regard to the FRT.
My lord, two things, my lord.
Whether they are playing with the minor, the newborn babies.
No, my lord.
Well, sir, a chairperson, you are all above.
My lord, not at all. My lord, kindly see the condition of the baby.
I don't want one condition of the baby. You have read the final report. How the condition is not the mother and father. It's the grandmother who has thrown the child in the nala at the bushes.
My lord,
but the unfortunate she died. Otherwise, she could have been proceeded with the under the Juvenile Justice Act.
Well, absolutely. My lord, we cannot stand in the way.
So
only.
So where is the child? When you tell me, when you produce the child before this court, I will tell the mother and father will come here and you have to
get any date, any date.
I will not fix the date. You ascertain the date when the chairperson along with the minor, the minor will come here, and I will direct both the mother and father to come here, and I will hand over the child in the court itself.
My lord, kindly fix the date and time.
You tell, because tomorrow you will say my officer is in SIR.
My lord, kindly keep it in Monday. My lord, I shall inform, in to be mentioned, I shall inform the date and time when I shall talk with my client.
The total CWC committee along chairperson and with minor, the child has to be brought before this court. Or I will send it to the mediation center, not before this court. It is not good to bring the minor child here.
Yes. Your lordship has all the money. We shall cooperate.
How this report can be filed? You have not gone through.
My lord, I have gone.
Then?
My lord, but FRT report of the is not.
So if I accept again, if FRT report is not within the knowledge of the committee, how we have given the adoption?
Well, there is.
How they have given the adoption?
There is a
without waiting the report of the police.
Well, there is an absolutely, my lord, there is a procedural defect.
Not procedure. Let they come. I will see how the procedure, whether they will continue as a chairperson of the. See, they are not a fit person to be continue as a committee CWC.
My lord, kindly fix it.
I don't know how many childs have been sold out.
No, my lord, kindly.
Why? What this has happened?
My lord, do not make such comment. My lord.
I will.
My lord, I tend my apology. My lord, don't. My lord. I pray before your lordship. My lord. Kindly.
Don't play with the court. Don't play with the court, and don't to put this type of the authority as a committee. At the learned counsel for the respective parties. This court finds that at the the petitioner has filed the present writ application praying for a direction, praying for setting aside and quashing the order dated 18/11/2024 passed by the respondent number 2, and to direct to hand over the minor son to the petitioners. Police stop. The police. Where the child, how the child was deducted?
My lord?
How the child was deducted? How the child was deducted? Where from?
Yes, my lord, your lordship will find that, my lord, at the final report which was submitted by the police.
My lord, at the my report page 1.
No, no, final report of the. Or page number 83. Second paragraph.
83.
Page 83. In the police version, after investigation.
This is FIR, I think. So, no?
83. No,
80.
FRT. Relevant portion, my lord, would be page 83 first paragraph and page 84 second paragraph. That was the initial script.
The police of PS, the police of PS, which PS? Your document is not legible. PS Maniktala.
Page 84, second paragraph.
Maniktala registered an FIR. Registered an FIR. Being FIR number 83 of 85 of 2025 dated 2024.
24.
Dated
13/6/2024.
13/6/2024. 2024 on the allegation that on 23/3/2024 at about 21:05 hours, one Ritam Das and some local pupils how the writ petition has been accepted by the department without the legible copy?
This is what I changed. I am.
Simia Road, which road? People Simia Road.
Yes, sir.
Came to the PS with the injured newborn male baby for seeking police assistance for necessary medical treatment of the said newborn baby. Full stop. The Ritam Das was claiming himself as the biological father of the said newborn baby and also reported that the baby was fallen from a height in an adjacent space of the premises. Immediately they have been accompanied to proceed to Arjikar Hospital. In the meantime, one unmarried lady, Ashmita Podda, arrived at the hospital and claimed herself as the biological mother of the injured newborn male baby. Finally, the injured baby was admitted in the SNCU OB gynecological department as unknown despite of several persuasion from the reported biological parents. The attending doctors refused to incorporate the particulars of the reported biological parents in the hospital records to avoid any future confusion. Full stop. After initiation of the FIR, police has conducted investigation, and on completion of the investigation, the police has submitted final report holding that is page 96 here to here. Type police. In the meantime, the petitioner had approached before this court by filing a writ application being WPA number 12471 of 2024. And this honorable court, by an order dated 3rd June 2024, has disposed of the writ application by directing the Child Welfare Committee to take steps to ascertain as to whether the petitioner is the mother and Ritam Das is the father of the child in question. Full stop. Again, the petitioner has filed, in spite of the order passed by this court, the authorities have not taken any steps. Accordingly, again, the petitioner has filed a writ application before this court being WPA number 12471 of 2024. And the said writ petition was disposed of by this court on 3rd of July 2024 by passing several order by directions. Full stop. Now the petitioner has filed the present writ application praying for custody of the minor. Full stop. From the record, it reveals that after the initiation of the FIR, the police has handed over the newborn baby to the Child Welfare Committee. And during the investigation, the paternity and maternity test was conducted. And on receipt of the report, it was found that the writ petitioner, Srimati Ashmita Poddar alias Payal Poddar, is the biological mother, and the husband is also a petitioner here. No. And what is the name? And Ritam Das is the biological father of the minor. But in the meantime, full stop. In terms of the order passed by this court, the CWC has, the chairperson of the Child Welfare Committee has filed the report wherein it is mentioned that as per the Juvenile Justice Act, Child Welfare Committee is the custodian of the child in need of care and protection, and the welfare and safety of the child supersede the biological ties when the parents are untraceable or where the prima facie appears unfit or have failed to safeguard or to protect the child. And in the factual background, the committee has and when the adoption was completed.
My lord, kindly come to report, my lord, adoption procedure and complied with 2. First page.
And accordingly, the CWC committee has completed the adoption proceedings on 1911. They have not given the name. On 19/11/2024. And at present, the child is not under the custody of Child Welfare Committee and has been placed in the pre-adoption foster care. Full stop. This court, full stop. The state has also filed the report wherein it is mentioned that during the investigation, DNA was conducted, and on receipt of the expert report, it was found that the newborn male baby matched with the Asmita Poddar alias Payal Poddar and also with Ritam Das. Full stop. This court failed to appreciate that the CWC committee, without taking into consideration and obtaining report from the police authority with regard to the investigation of the case initiated by the police have given the child in adoption, given the child in pre-adoption to the foster care. Full stop. In view of the above, this court is of the view that as per the report submitted by the police, neither the petitioner nor the Ritam Das are the culprit for having sustained are the culprit of the case initiated by the police of PS Maniktala. It is established that both are the maternal and paternal biological mother and father of the male minor baby, and as such, the committee is directed to where the child will be produced.
Well, not it's not been convinced. Well, I'll send mediation center on the or your lordships any day. Well, as it's happen in chamber, if in chamber.
क्या बोला लास्ट में? Director to produce the minor child. The child along with all documents. In the खाली होगा at the conference hall of 8th floor of the Saskia Century building on 6th मार्च को देखो 12 बजे कोई मैटर है? बारह बजे है? कौन दिन नहीं है 12 बजे? मंडे ट्यूसडे 10 9 10 6 तारीख भी है? Okay, on 6th of March 2026 at 1 p.m. The petitioner and the Ritam Das are both married or not?
Married.
Are also directed to be present along with the learned advocates with proper documents. Let the matter appear on 6th of March. You will get it. Close.
Why I tendered my apology, my lord. Do not take me amiss.
Nothing. Case is over. Now all the thing is over. Not keeping with the skin.
That I learned from you. Great. Yes.
May I be permitted, my lord, to mention the matter?
Yes.
The other side is here. It's fixed at 3 p.m. today and tomorrow. Tomorrow is also 3:30. And your lordship will fix another 2 days.
Tomorrow
My
is 3:30.
argument is to begin.
Which one?
It's item 6, I think. It's fixed at 3:30.
The central bank.
We have to begin the argument.
My lord, in this matter, the advocate on record has expired, my lord. So I have received the instruction from a bank to appear this matter. But since he is not available, we have to take all the briefs and the details from his family. And
But it's my argument is beginning. This was already adjourned on this ground from December. But be that as it may, your lordship fixes a date, I'm sure. And my learned friend will record his thing.
Yes.
Any day, your lordship.
Fixing a date is a very difficult task.
So it was fixed in January. Then, unfortunately, my learned friend's predecessor died.
March. 3 p.m. nahi hai.
Can it be on a 2 p.m. one day?
That you're not getting a 3:45. 16th April 2 3 or
I forget,
16th April.
16th.
Item number 6, huh?
April.
6.
Well, March. One day at least let us start. Let my learned friends will come and say they are not. I'll take
March
2 or 3.
3:45 देख लो 2 दिन दे दो फिर देखेंगे आगे.
Even if I get 2 minutes, I can tell my lord now, the case is I have made a fixed deposit in 1984. I haven't got it back yet. I should stop there. That's my case. It's only 40 years.
24th March at 3:45 and 24th March and so appearing for the equity then. Though the matter is fixed today, especially fixed today.
Today and tomorrow.
For hearing, but due to paucity of time, the matter could not be taken up for hearing. The matter is already fixed, also fixed tomorrow. Police, so counsel for the defendant, you are for the plaintiff. Counsel for the plaintiff
Wakalatnama not filed.
submit that he has some personal difficulties and is not in position to argue the matter tomorrow. Accordingly, case is adjourned. Let the matter appear on 24th of March 2026 at 3:45 p.m. and 16th April at 3 p.m. and 23rd of April at 3 p.m.
Grateful.
as a specially fixed matter.
This order 7, rule 11. Everybody has finished for your lordship's order, and they also made their reply. Thereafter, your lordship has
That
recorded.
one?
No, I'm not.
Yesterday, madam. No?
Yes, yesterday, madam. But it has been closed, my lord. There's no point in further keeping it. Kindly keep it as to be mentioned and let them, my lord.
It is fixed today.
No, it was fixed yesterday, but today it has gone down in the list.
So today the court applications. No, that's it. It will come tomorrow. What is the number? Tomorrow. इसको एक काम करो ऊपर रख दो. ऊपर में कर.
153.
तो ऊपर में आ जाए.
Let it appear on.
No, it will come as a number 1 or number 2 mat.
Instead of tomorrow, make it Monday.
Monday now.
Monday.
Monday.
Oh, actually, wait.
Wednesday, Thursday.
Thursday.
My lord, item number.
This matter, my lord, under extremely urgent circumstances are mentioned.
Friday. Friday. 6.
Very well. But to be mentioned, let it appear.
No, it will come 1 or 2. Item number 1 or 2.
Okay.
This matter, what has happened, the petitioner.
Okay.
My lord, yes, on 18th of my lord, an undated, unsigned show cause notice has been sent, saying, leveling certain allegations and asking for a show cause. Lordship, that is
Who has sent the notice?
the GEM admin.
GEM admin, yes.
And Lordship, they have stated that within 10 days you reply or your account will be suspended. Lordship, there are two reasons for the urgency. My lord. First and foremost, my lord, there is no adjudication process in the GEM system. My lord. I have submitted my reply, my lord, without prejudice, my lord. They will anytime, my lord, use that and suspend me, my lord. I want to show, my lord, that there is no provision, my lord. The allegation that they are leveling on me, there is no provision to level such allegations under the GEM.
So you are registered under the GEM.
Under the GEM.
So you are supplying the materials.
Yes, ma'am. Now, my lord, if the 28th is the last.
You are not paid the amount.
No, my lord. My lord, what they are alleging is that some other persons have the same IP address during the bidding, my lord. Completely separate entities, my lord, not connected with me in any manner, my lord. They are saying that because.
So what you want?
I want, my lord, this matter may be taken up tomorrow, my lord, that certain protections need to be given, my lord, or my GEM portal will be suspended, my lord. I have 28 bids.
When you receive the notice?
18th February, my lord.
Huh?
18th February.
18th February. So what you are doing till date?
They have replied and then I am coming before my lord because I don't want to shy away from the investigation, but some protection needs to be given, my lord.
18th February, 10 days. 10 days so cause notice. 28. Which appellate original side?
I will not take, my lord, more than 5 minutes. I will show from the documents, my lord.
Can you?
I'm so grateful.
My lord, may I be permitted to mention?
Your lordship, this is item number 5. Item number 4, your lordship had appointed a special officer for evaluation of compensation. And that is the cold storage matter. The insurance claim, your lordship was used to pass this preliminary decree.
No appeal.
We are the one who has received your lordship's grace. No appeal from the insurance. So, your lordship will see paragraph 15.
Yes. 26 February filing report.
Post he had given 1 day, but after that, so I am requesting your lordship to extend it. The 3 more months will not make anything.
The matter is fixed today for filing report in terms of the judgment passed by this court dated. I'll report by the special referee or special officer. Special referee in terms of the judgment dated 21st November 2025. Counsel for the plaintiff submit that the special referee has issued the notice for hearing, but in the meantime there was some difficulties due to which the hearing could not be completed by the special referee and accordingly prays for extension of time. In view of the submission made by the counsel for the plaintiff, time to file report by the special referee is extended for a further period of
3 months.
for a further period of 3 months from date. Let the matter appear. आज क्या date है? 26 March. Let the matter appear on 9th June.
My lord, item number.
Lordship, my matter was supposed to come on 20th, and today's 25th, and it's going down the list. Could you just take it, fix a date?
Which side?
It's it's WPO 807.
It is there.
So it's there, it's going down the list. And
Not gone. One day I am taking the writ matters, another day I am taking the original side matters. So
the
next
original, it's the original writ matter.
so next original side writ matter.
Yes.
Which matter?
So 807, sir.
Item number?
Today's the item number is 68, I think. WPO 807, sir.
Of which year?
25.
Item number 26. Item number 26 is there.
Right.
It will come. Yes.
My lord, may I be permitted to mention item number 3? My lord, on last occasion, my lord would remember that we have paid a check of 4.5 crore, which has been cleared, my lord. The other side is there, my lord, and an order may be
Telling
passed.
that he has not received.
No. We are.
My lords, may I, my lords, I appear on behalf of the contemners in this matter, my lords. My lords, I was there on the last date of hearing and I handed over the checks for 4.5 crores, my lords.
But we have
My lord,
my lord, subsequent the affidavit, this mail was given by the plaintiff to the defendant, my lord. On basis of this mail, we have paid the 4.5.
Now, what was the original order?
Original order was for
payment. You have to pay the interest because you are default.
Original order was for payment of 8 crores. Then they have given a mail. Then we have issued a mail.
8
that
crores. If it is settlement, if it is not paid, it will delay. Then the interest will carried out.
my lords, only one thing. My lords, may kindly hear me just for a minute. My lords, may kindly hear me for a minute, my lords. My lords, when this payment was due, my lords, we spoke to them that we are ready to pay 4.5 crores as lump sum on or before 18th. They said they sent an email back to us, my lord, saying that if you pay 4.5 crores before 18, we will issue you a NOC, my lord. My lord, in terms of that email, we have made the full payment of 4.5 crores before this honorable court, my lord. It is my respectful submission, my lord, that once they have on their own agreed to take 4.5 crores, and in terms thereof, my lord, I have paid the entire amount of 4.5 crores, my lord. Then today they cannot backtrack, my lord. Just because, my lord, in the past my conduct was wrong, my lord, I was financially dependent, my lord, but I have now paid each and every penny, my lord, in terms of that settlement, my lord. So it is my respectful submission, my lord, that having agreed and having taken money, my lord, now they cannot backtrack, my lord, from that.
Okay.
My lord, we have submitted the mail copy.
So now what requires?
The injunction order needs to be vacated, my lord. I'm suffering. The blanket injunction on all property.
Please चुप हो जाओ, मैं आर्ग्यू कर रहा हूँ.
Counsel for the petitioner submit that the check issued by the alleged contemner on 18th February 2026 for a total sum of rupees 3.5 crore has been encashed. Full stop. We have the above. Let the matter appear on. Is that the उसका है ना? Original side का है ना? कब रखे? 5th को? 5th, 6th. Let the matter appear on 6th March for final disposal.
Much obliged.
Much obliged.
Mentioning about notice item number 138. This contempt matter. My lord, recollect me the LinkedIn profile was used for me against me Aditya Vikram Billa to upload me
Lordship, I am appearing for 5, 6, 7, and 8. Lordship, let the interim order be vacated. Lordship, let the interim order be vacated. Lordship.
Come on, 6. I will. That's a finally final order
in my matter.
this matter, my lord, had come up, my lord, with a my lord, recollect he came in the box and deposed my lord before lordship that he will not do again. Now, my lord, subsequently found that my lord, he has my lord, uploaded my lord, another my lord, article in his personal website. Now, my lord, on 4th of February, my lord had injuncted him, my lord, from kindly comes to my lord, the my lord, 4th of February order. My lord had injuncted him, my lord, from causing any further publication or displaying. So, my lord, the interim order is expiring today. I'll be seeking an extension, and the displaying is still being continued as of now. I could have brought a printout, but I've told to show as of now, standing in my lord's court. Kindly I'm seeking I was prayed I prayed for prayer A and B last day. He has to be police authority has to be directed to detain him. Otherwise this will continue. He has taken for a toss, as of now, in standing in my lord's court, it still continues. The displaying still continues. In the last day, he has not filed any affidavit. Last day, one advocate, a third advocate appeared. The
matter is listed as
serial
number
138.
138. But the same could not be taken up for hearing. Accordingly, learned counsel for the petitioner has mentioned the matter and submit that the interim order is till today and paid for extension of interim order. He further submit that though this court by an order dated 4th of February 2026 restrained the respondent from causing any further publication or displaying any kind of defamatory statement or words or dialogues in any form or in any manner or in any nature. But in spite of the order passed by this court, still the alleged contemner is publishing what is
displaying the same thing continue.
Displaying the defamatory statement. Full stop. Consider the submission made by the counsel for the petitioner. He
has also not filed the affidavits.
Full stop. The counsel for the petition further submit that the respondent, the alleged contemner, has not filed affidavit till today. In view of the above, the interim order passed by this court is extended till 25th of March 2026 or until further order, whichever is
and also prayer A and B.
Let the matter appear on 20th March 2026 and the alleged contemner is directed to appear before this court in person. The petition is directed to communicate this order to the to the alleged contemner.
Obliged.
Mention one matter for English. For English.
Obliged.
For
English.
Deeply obliged.